Yo, 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 how we doing, people? Hope you're all well out there. Oh, I just noticed I made a mistake here. I need to change this to my Twitter account. Hang on, I'll do that now. Happy days, Dylan. Happy days, Dylan. Happy days. So we are. It's Friday. It's like any other day for me, really, but for some of you, it's going to be a huge day. End of the working week. Now, we'll have to see when Sarah P comes in, whether we need a ticker at the bottom or not. I'm not sure if she's grumpier yet today. So we shall see. We shall see. But anyway, I hope everyone's well. I'm excited for today. I'm excited. Uh, I've got quite a few things to go through for this deep dive. So I thought it would be a couple of hours, but actually, I reckon we're going to be like at least 3, 4 hours on this deep dive. Um, or at least 3 hours, I should say. So, because I found out quite a bit of stuff. If you are on replay, then obviously jump on about probably 10 minutes. Um, but if you're watching live, we'll just give it a little bit of 5, 10 minutes just to get everyone in here. But before they do get in here, oh, you're good, you're good, you're good. Sarah Pete, look at her. Welcome everyone. Thanks for joining. Please hit that like, subscribe. I've had quite a few subscribers overnight. I don't know where they came from, but thank you guys for subscribing. Hit that notification bell on the way in as well. Thank you very much. Now, this is important. Please, if you're able to, join the Ultimate Corner community. Woo, we're dancing. If we had new member overnight, so I'll introduce our new member in a second. But we've had one new member overnight who was a blue wench. So it's 2 levels: tackle level and blue wench level. Um, so you get both gets access to Discord, both gets access to members only, and I'm trying to do it so that for a blue wench, you get a little bit extra, more of a direct time with me, you know. Um, whether you want that actually be off-putting, you want to be a tackle then. But yeah, 2 different levels just to see if you can afford it or not. So I appreciate if you can't be a member. It really helps me out, pays my wages, pays my bills. But if you can't afford it, don't worry about it. Still be here because we are still doing, content. I think members only last night was really good. I enjoyed it. I know we found out Jonathan's very squeamish, which I love. Lou is squeamish, which I love. It's quite a few people are squeamish. Katie's a little bit squeamish, is it? Good morning, Katie. You're a little bit squeamish as well. I love it. I enjoyed it last night. Um, yeah, also check out. I haven't really pushed my merch store. I know that some of you bought some stuff. Let me know what you think of the stuff. Um, from the comments I've had, people think it's great quality. Brilliant. So if you fancy some merch, please go. I'm crap at selling myself, but if you fancy some merch, go over, have a look. If you don't, jump in. Don't worry, it costs me nothing. So, main thing for me, guys, is if you want to support the channel, become a member. Because the more members we have, the better community we have on Discord and also dealing members only stuff. So I'd love to see more people become members. Follow me on Twitter. So I've started a new account now. One account is my personal, which most people don't like me, my personal account. So, I'm a little bit outlandish on that one. So don't follow me on that one. Follow me on the Alternate Corner one, which is where we promote everything Alternate Corner. Consider supporting the channel with a donation. Again, it's never required, but always appreciated. Again, if people can't want to contribute to the channel, I don't expect anything from anybody. Um, but as I say, it's always appreciated. It goes through Stream Elements. Now, the reason I do that is because then it pops up, so you can change your name on Stream Elements. Then when you give the donation, and it pops up on screen, so you can stay anonymous if you wanted to as well through that tip. They take 9% from it, but it's much better than super chats. Super chats are I literally get about 30% of the super chat, so it's not worth it. Um, Get a shirt, help Zach. Yeah, we could design one particular shirt. And from that sale, $10 or £10, whatever it is, I don't remember what it is now, will go as that. Basically, all profits essentially to Zach. I think I get £1 or something, £2, but Zach gets everything for his fund. Good morning, Katie. Hello, Sarah P. Right, is a ticker going on or not? Is a ticker? Hi, Sarah P. Good morning, Katie. Happy Friday, happy days. Happy Friday, happy days. Yes, it's happy days every day. Uh-oh. You need to change your name to Squeamish Jonathan. I'm surprised at you, Jonathan. I thought you would be non-squeamish. I can't believe how squeamish you are. Unbelievable. You shocked me last night. I loved it. I loved it. Uh, what's the good news and bad news? Now, you're not divorced. You can't be. Not overnight. You can't be. But the good news is you probably bought that thing you wanted to buy, the thing for the exhaust. And the bad news is the wife's pissed off. I think. You old good old chestnut, you. Hey, Jonathan. Oh no. Good morning, Thierry. Good morning, Thierry. Good morning, Frankie. Hello. I was with you last night for a little bit, Frankie. Saw you doing the Delphi case. I'll have to watch that again because I'm way behind on the Delphi case. But I'm doing my own deep dive today on this case, Jesse's case. But go. But yeah, I will come back and watch that because you said some interesting things. And if you do want to cover the Delphi case, guys, go over and have a look at the think tank because um, I know that Frankie covered it last night and it looked interesting. So I'll probably do something myself on it. In a month or a couple of months. But for now, if you've got because obviously things changed last night. Because I'm going to concentrate on this trial now and also Karen Reid. So I haven't got time to do everything. So the Delphi case, go over and see the think tank with Frankie. She covered it a bit last night, and I'm sure she'll cover it in the future. So Sarah P, go ahead and put it on. If we put, oops, if we put it on, then things will go okay. Okay, yeah, I want it to go good for you today. So we're going to put this on. General warning: Sarah P's in a bad mood today. Approach with caution. So we want Sarah P to have a good day. So I'm putting it on. So no one pick on Sarah P today. I'm not even going to pick on her. Well, I mean, I'm a little bit picking on her, but not too much. Hey, I'm a little late. Looking forward to hearing about this trial. Sandra, I got loads. I'm excited for this trial. Now, I got docs. I got everything. I got the complaint. I've got a video of the last court appearance. I've got a breakdown of the attorneys. I've got, oh, guys, you get everything from me. So, you got everything. But hi, Sandra, by the way. Good morning, Thierry and Think Tank. What the hell wasn't the eye drops? What the hell wasn't the eye drops? Right, what the hell was in the eye drops, Perry? You were testing me out when you were testing me out there. I know. Um, Thierry, Sandra, get into it now. Hi, Sandra. I'll be in and out. It's all good. Thank you for being here. Do you know what I mean? I tell everyone all the time, even if you come in and say hello, I I don't care after that. Do you know what I mean? I appreciate it. So thank you for even being here, Frankie. Appreciate you for that. What the hell was in the eye drops? We'll cover that. We'll cover that in a bit now. Hey Perry. Hi everyone. Thank you so much. Oh, I need to watch some of your. Yeah, so I became a member of your channel last night. So I need to watch. I saw something about your. Was it a condo? Something that you got about a lake or something? I haven't looked at anything yet. I need to look at some of your members only videos because I think you do some personal ones as well. So that'll be interesting to watch because I want to do some of them as well. Hello, Nancy. Hey, Sarah P. Hey, Perry. Morning, Sarah. Hey, Frankie. Look at this is what I love about the chat. Hey, Perry. Hi, the think tank. Hey, Katie. Everyone just says hello to each other. It's brilliant. Morning, Sarah. Morning, Kay. All I know is this case is in Judge Dora's court. Yes, but I've got the documents. I've got everything. Katie, I got you covered, girl. I got you covered. But shout out as well overnight to one of my OGs. But she hasn't been here for ages now. Because she goes around different trials and stuff. But when she is here, she's awesome. I did tweet at her, but Rosie became a member last night. She became a blue wench last night. As I say, we've got two levels: tackle club level and blue wench level. And she became a blue wench last night. As you can see, the picture blue as well, just to resemble it as well. So thank you to Rosie. Rosie is a reason why I get confused between Josie. So this is Rosie, who I keep calling Josie Rosie. Literally, this girl is the whole reason I call Josie Rosie. So true story that is. So whenever you see me calling Josie Rosie, just be known this is the reason. Um, but yeah, she's a day one. She was with me basically right from the first week. So, but as I say, most of you probably don't know her. She hasn't been here for a while, but she does lurk a little bit. Um, but as you need to go around other trials and other people as well. So, right, yeah, welcome to the Blue Wenches, Rosie, 100%. Now, I know you're excited to see me. I know, but we're waiting on Jonathan. Jonathan, what's the good news, bad news? Did I miss it? Jesus, I'll go straight in the blood. Good news, bad news, Jonathan. What is it? Did you say what it was? No, I don't think he did he? Jonathan. Yeah, Jonathan, I want to know what the good news, bad news is, Jonathan. Um, hi, Jumpy. Hi, Jumpy. Hope you're well. Oh, some lovely, lovely, lovely people here today. It's sometimes we don't get, I like everyone that's here today. I like, so it's fine. Right, we will get started because it's 2 more minutes. We'll get started. Jessy Kurczewski. Jessy Kurczewski. Kurczewski. We'll get it. We'll get it. Yes. Could you believe this, right? So John said he's got good news, bad news. I said, go on, John, go on. Just gone quiet. Just gone quiet. I called him out though. So Jonathan, we had members only last night, right? We were watching a car chase, which wasn't a car chase. It was a slow chase, for an hour and a half. And then we watched the cows getting their hooves, getting ulcers and stuff, getting out, basically become pain free. Oh my days. Jonathan was so squeamish. Like I understood Katie was squeamish, Lou was squeamish. I can sort of understand. Jonathan, big guy he is, I thought he's never gonna be squeamish. Absolute squeamish. He's like a baby. So maybe that's why I called him out now, Sarah. Maybe he just doesn't want to speak to us anymore. He'll be back. Great to see everyone. Great to see you, Frankie, as well. As I say, Delphi stuff, guys. Go and see Frankie, the think tank. Um, I'm sure we'll post a link to it now. Don't worry, Frankie. We'll post a link. I'm not really covering the Delphi. I will stream it, but I don't really know that much about it. Um, a lot happened with it yesterday. I did call out that the wife was involved in some way or another, and I think that she is somewhat. But Frankie covered it. I haven't got the time to cover it, so please go and watch Frankie's stuff. As I say, I was intrigued with it. I only watched probably 10 minutes of it, but um, keep going. With that, if you can find this, Sarah, post a link to Frankie's channel so we can um, get people that way because I can't cover all trials, guys. So, and when I see good content, I like to. Um, Here we go. Sarah's done it. Subscribe to the think tank. Yeah, she covers a lot of research stuff that I like doing, but I don't have the time to do either. So we will. I am going to do one on Karen Reid, 100%, and I'm doing this today. So Delphi, I don't have the time, guys, so go and see Frankie. But I might do something, but not. I might actually, Frankie, I might get you on here to do something with me on it in a few weeks or something. See how it goes because I am interested in it, but and I want to hear from you as well. So, great to see everyone. Great to see you, Frankie. Hiya, Katie. Tried to join, technically difficult to figure out. Don't worry about it. Hey, I never expect anyone to join, Frankie. But obviously, if you want to, happy days. But um, no, just because I joined you, there's no expectation to join you back. Don't worry. You know, but I appreciate it. It's all good though. Don't forget to smash that thumbs up for it. Yes, the thumbs up, because some people forget. I have a large Delphi playlist. There we are. Happy days. I got a little bit on Delphi. One episode, and that's it. So head on over, guys, because I don't have the time. So there we are. Great source here for you guys. And I don't normally promote, like, you know me. I don't really, um, you know, promote other streamers, but I have watched a bit of the content, and I do think it's good. So trust me, you should go over. A lot of people are nice there, and you know also who's in the chat. Perry's there, so it's going to be intellectual, but it's not too intellectual because obviously I was there. So bring it down. And Meki Tech and Sean are there as well. So a lot of the same people are in the chat, guys. Such a mess. I know it is, isn't it? Subscribe to the Think Tank. Think that I will have to check it out. Please do, guys. Thank you. No worries. Think that are good. You're following Marjorie and Kayla too. There we are. Another case. Oh, weird. But as I say, don't worry about it. It's all good. It's all good. Thanks for the link, Sarah. Subscribe. Happy day. So everyone subscribe. Right, let's get started. Otherwise, you're all like, fucking hell, shut the fuck up and get on with it. I'll be like, right, okay, yeah. Right. So let's get the first document. Let's get a bit of background on this, right? Oh, I'm excited. Like you just can't hide it. Right, so which one's the first one? No, this one. Is it that one? Yes, this one. So, oh my God, Sarah, please tell me to stop cursing. Sarah P, I know, my bad, my bad. I got too excited. Sorry, I got too excited. My bad. Got to wait till 2 hours to curse. I've been limited the last 10 videos, by the way, so I need to. I'm doing something wrong. Right, Washington Post. Try for 4 weeks free. No, thank you. Right. She said her friend died by suicide. Police say she stole thousands and poisoned her with eye drops. So, Perry, this hopefully will explain to you what's going on. So, when Jessy Kurczewski, Kurowski, Kurkowski, Kurskowski. When Jessy Kurskowski, we'll go with Jessy, called 911 in 2018 to report a friend was unconscious in a Wisconsin home. I think they were quite besties. Police arrived to find the woman on a recliner with crushed pills on her chest and several prescription bottles nearby. Oh, I think it's Kurszewski. I was right then. Kurszewski. Kurszewski. I was not bad. Jessica Kurszewski. Oh, thank you, Think Tank. You did. Thank you very much. We got members only and Discord and stuff like that. Thank you very much for becoming a member. I really appreciate you for that. So we got a few members in the Taco Club now. Happy days. Basically, you get the same access to both, so it doesn't make a difference. But thank you so much, Think Tank. I appreciate you for that. Um, K- Kershowski told fuck, oops, friggin' Nora, Waukesha, Bloody hell, what the hell is all these names about? Kershowski, Kershowski told the Waukesha County Sheriff's Department she was a woman's only friend. So I didn't say it. Welcome to Think That. Thanks for joining the Taco Club. I didn't say it. I didn't say it. I said friggin' Nora. I got a phone call. Hang on. Hello? It is, yes.
called Eco 4, which could potentially be eligible for in the property that you're in. But to meet the requirements for it, do you have a total household income that's below 31,000? Do you receive any benefits, or are you retired?
No, no, I'm above that. Sorry.
Okay, no worries. Thank you very much for your time.
And cheers. Take care, buddy. Ta-ra. You see, I thought it was a cold call. Oh, da iawn. So I didn't say it. No, so you said it. No, I didn't. Wakasho. Okay, maybe I did start to say it. Wakasho. Wakisho. Emphasis on the first. What? Anyway, you know what I mean. You know what I mean. Bore da ti, Emma. Gobeithio bod ti'n iawn. I hope you're okay, Emma. Bit of Welsh for you there. Welcome, Em. You've not missed anything. We just started. I can't say the words Americans. You don't get this in the UK. Soft A. Okay, so Kurczewski told the WAUKESHA County. That's better, isn't it? WAUKESHA. So don't say wa. Say we. Whoosh. WAUKESHA. WAUKESH. WAUKESHA. Oh, anyway, you know what it is. You know what it is. Um, right. Her friend who was ill and sick of being sick may have died by suicide. Um, she suggested. So yeah, she's trying to pin it. That was suicide. Weeks, police believed that was possible until the woman's autopsy came back with a strange result: a fatal amount of Jesus Christ. I mean, what are we doing? I should read these beforehand, shouldn't I? What the hell is this? Tret, tet, tet, tetrahydrozoline. Tetrahydrozoline, the main ingredient in eye drops in her bloodstream. The amount in her blood couldn't have been taken in through her eyes alone, police said. Now authorities have charged Kurczewski, 37, with a murder in connection with the death of the woman, who isn't named in court records. Police also say Kurczewski, who had a gambling problem, oh Jesus, committed more than $290,000 fraud using the woman's accounts, according to a criminal complaint filed Friday in WAUKESHA County Circuit Court. Court records. Hi, Cuddles. Waukesha, Waukesha County. Okay, I can say that, Waukesha. Thanks, Sylvia. Hiya, Sylvia. Waukesha County. Um, so obviously, if you want professional readers and deep dives, then don't come here, guys. I mean, I've not looked at these beforehand because I want to go through it at the same time as you. And also, I'm not a reader. Do you know what I mean? I'd like to see. I mean, some other people can just do this professionally. I just can't. Yes, you got it. Happy day, Sylvia, for the win. Waukesha. Let's go, Sylvia. Waukesha. Um, in the weeks after, police responded to the woman's house on October 3rd, 2018. Kurczewski, a resident of Franklin, Wisconsin, repeatedly changed her version of events, authorities said. That day, Kurczewski, who had keys to a friend's house, told police her friend had been recently released from the hospital and had been acting oddly that week. Oh, surprise, surprise. Her friend kept telling her where important documents were located, gave her instructions about what she wanted done with her cats, and asked not to be put in a nursing home, she said. Kurczewski indicated she believed there was a possibility that um, the woman was suicidal, but also stated she believed she really loved her cats, often worried about them, and wouldn't want to leave them behind, according to the criminal complaint. Authorities didn't begin to consider Kurczewski as a person of interest in this case until months later, when the woman's relatives, friends, and neighbors told detectives that they doubted the woman had plans to kill herself. They also raised concerns about why the woman would leave all of her possessions to Kurczewski and none to her family. Well, that's a bit dubious, isn't it? Do you know what I mean? That was a good way. Sylvia for the win. That was a good way, Sylvia. That was a good way. Can't help with the Polish last name though. Would be too hard to explain on. That's fine. I mean, look, you know what I mean. Do you know what I mean? You guys know what I mean. But it wasn't until January 2019 when medical examiner delivered a toxicology report that police reopened the case. They arrested Kurczewski in July 2019 after conducting a search warrant at her home. So he said she had told witnesses elaborate stories. Like, it is a bit dodgy when, you think if you're gonna stage a suicide like that, you won't just keep all the money yourself. Use a bit of common sense. Yeah, give yourself 40% of something, but give some to the family. I mean, because he's just highly suspicious. Highly suspicious now. So no wonder family and friends are peed off, Police said she had told witnesses elaborate stories about what had happened. She had claimed the woman had been in a coma for 5 months, and also that a hospital bed revived her against her wishes, which authorities later found never occurred. Oh, okay. When she was told about toxicology results, she said her friend was known for buying eye drops in bulk and drinking Visine, 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 and vodka. Jesus. At first, she denied any role in her death or in staging a scene with the crushed pills. But eventually, she changed the story again. She claimed she did give her a water bottle containing six. What the hell? She did. She claims she did give her a water bottle containing six bottles of Visine because the victim asked for it. Well, you're done for, new girl. She said she could prove she gave her a fatal dose of tetrahydrozoline at the request with evidence she had buried in a plot of land. Authorities dug up the area she indicated but never found such evidence. This woman's thick as crap, isn't she? Her cellmate at the right, right. Why can't Americans be normal? What the hell is this? This is not an English lesson. So, cellmate at the Tachida Correctional Institution, where she was later transferred, later told detectives Kurczewski had a mental breakdown and admitted to giving the woman several bottles of Visine to kill her, but not for money. She did this, she claimed, to stop her friend's suffering. Well, you can't. But if she hadn't admitted to that, it'd be quite hard for them to prove this. But now you just admitted to killing her. That's Native American. Well, I apologize. I don't mean to take the P out of them. It's just I find it quite difficult. So I apologize for butchering these. Obviously, it's trying to be funny. I'm sorry for butchering the names. So I genuinely mean that. Sorry for butchering all these names. Um, but in court records, police say that Kurkowski began spending more on lavish gifts and gambling um, as her contact with the woman increased, and that she began transferring funds from the woman's account to her own. When the woman died and she became the sole recipient of her estate, she allegedly created fraudulent documents to pay for debt that didn't exist, so she could pocket more money. Kurowski allegedly transferred more than $130,000 via fraudulent checks from the woman's account as part of a larger fraudulent scheme. In addition to first-degree intentional homicide, a felony, Kurowski also faces two felony counts of theft. Her bond was set at $1 million, and a preliminary hearing is scheduled for June 25th. Court records show. Um, so lots of Indian, Native American names in Wisconsin. Some are really hard to figure out. That's fine. That's not just me. I did catch an earlier rundown. Sounds like victim had dementia and was already spending bucks. Did victim have her friend tell her about fake coma because she didn't want him her seeing her like that? Maybe, I don't know. Well, I mean, we might find out. So that's the first document. Second document, then, where we are now. I think she's a bit thick. That's for sure. Because she's admitted to basically giving her the eye drops, which, well, that's a massive red flag, isn't it? Court TV. So this is as of October 3rd now, just so we know. WAUKESHA County, Wisconsin. A Wisconsin woman is facing life in prison if convicted of killing a friend in her care by poisoning her with eye drops. Jessy is charged, 39 is charged with 1 count of first-degree intentional homicide and 2 counts of felony theft. Prosecutors say she killed Hernan, who she was caring for, and staged the scene to look like a suicide by drug overdose. Hernan reportedly died after drinking a water bottle mixed with 6 bottles of Visine. Kurczewski told police Herman was suicidal and had not been trying to kill us and had been trying to kill herself by drinking Visine and vodka, according to criminal complaint. Investigators say in total Kurczewski stole $290,210.06 from Hernan before and after her death. Hernan died on October 3rd, 2018, and Kurczewski was arrested on July 9th, 2019. Okay, so there's a bit of time then. There's a bit of time. His trial is expected to start on October 23rd by Judge Doro. Um, so, in other words, she knew she was going to do it and didn't stop it at the very least. But the cover up and fraud will bury her. Yes, I agree, Thierry. Jonathan, right, come on, tell us what happened. Lol, lymph node is not cancer. No, you're right, it's not cancer, no. Good news. The bad news is probably Lyme disease because it's responsive to Lyme's treatment. I don't know what Lyme's disease is. Um, but sorry to hear. I think it's not nice, but I don't know what. I'll have to Google it later, Jonathan. But hope you're okay, my man. Hope you're okay. There you are, Jonathan. You can't leave us hanging. No, I know. At least it's not cancer, but I still don't know from ticks. No, get rid of Lyme's disease. My wife has a friend dying. Oh, Jesus. Yeah, we're sorry. I had to switch phones. Can't see what you're typing on the other phone, but I had to try. Oh, thank you, Sylvia. Thank you, Sylvia. Well, Jonathan, I got everything crossed for you, my man. I have to look more into it. I'd be lying if I said I know what Lyme's disease is, Jonathan. I don't. So I'm not going to pretend I do. But yeah, I don't think she meant it. As in, yeah, thought that mid-call was important. Yeah, that's fine, Jonathan. You are excused for that. Um, yeah, I need to Google it later, mate. Um, hang on. I know you won't want us to treat you any differently, so I'm still going to slag you off for now until I find out what it is. Jonathan prays for good response for treatment. Yes, my wife dies for Lyme disease, so it just progresses. But hopefully, it doesn't progress for a very long time, Jonathan. I'm just concerned I don't know what it is. Price I pay to hunt. Okay, I need to. I will Google it at some point. Right, let's get into this for a second. Jesus. Right. So these are 3 counts. I mean, still speak to Jonathan. It's just more of I'm trying to get on with this as well. Because I don't know what to say. Right. Let me open this box a bit more. I'll put my pretty face a little bit higher as well. Save. Update layout. Right. So 3 counts. Charged with 3 counts, which are count 1, first-degree intentional homicide, felony A, on the 3rd of the 10th, all of them are. Second count, theft, movable property over $100,000. And count 3 is theft, movable property between 10 and 100,000. So imagine that's a gambling one more than anything, probably around 10 grand at a time or something. I blame that one little tick who bit right on the head of my pecker. I had to pull him off. Oh Jesus. So you see that. So defendant name Jessy Kurczewski. Date of birth. This is where I was going to say second of. Well, it's not second. It's the 18th of February 1984. Female, causation, yeah, white. Her address, stuff like that. Right. So one of the things I noticed is that she had lots of lawyers. Jonathan, great news that it's not cancer. Sorry about Lyme disease. I noticed my brother had Lyme disease, was treated early, and he's okay. That was probably 15 or 20. Oh, okay. Okay. So it's not all negative here. It is, fine. It can still turn into it. To my understanding, it was done shrinking how small it gets and after my ultrasound. Got everything crossed for you, John. Everything crossed for you, my man. You know we're here for you. Um, so she had um, Laura Ann McMahon and Paul Crawford as her attorneys here, but they withdrew. Paul withdrew on the 16th December 2021, but then he came back involved on the 29th of March 2022. Then he left again on the 5th of January 2023. Mora left on 29th of March 2022. Erin Mendon came in then, 16th of December 2021. She left on the 29th of March 2022 as well. Now we've got 2 attorneys here, Pablo Galaviz and Donna Jean Kuchler. That's um that's who we have as our attorneys. Um, so we'll see. Some long-term event, sure. Positive vibes, yes, towards Jonathan. So who are her attorneys? So as you can see here, right, it's all booked out 8:30 a.m. Central from the 23rd. Hi, Gilf. Hiya, Gilfie, my queen. How are you? I hope the first week in work is going well. You all hit the like button. Thank you, Gilfie. Well, that's freaking cool. Hey, Jonathan, Gilf's here, so that's gonna put a smile on your face. We need we need lots of praise and good vibes, Lady Law, towards Jonathan. He's just been diagnosed with Lyme disease, so we're all. And the fact that you're here, I know that's gonna really perk him up actually. So I'm glad you're here. Acid infection in the body and be told in a way, yes. Lady Law, hey lol. It's true though, John, isn't it? It's true. You get excited when she's around. So do I. It's not just you, it's all good. So this is scheduled for 1, 2, 3, 4, 5. 1, 2, 3, 4, 5. 2 weeks there. 1, 2, 3, 4, 5. 3 weeks. 1, 2, 3, 4, 5. 4 weeks. 3, 4, 5. 5 weeks. Now, obviously, it might not take 5 weeks. Yeah, that's the reaction I get as well, John. 5 weeks of trial. Start at 8:30 every morning. But obviously we don't know if it's gonna last that long. It's a 12-person jury. Um, 12-person jury. Somebody should have checked you out for ticks. Also, sorry to hear that. Hope you recover quickly. Yes. Stick those three emojis together. Yeah, well, it's my reaction when I see Lady Law. Do you know what I mean? Ticks are bastards. Yes. So we've got 5 weeks of this, yeah. Um, from 8:30 good, so that's 9:30 Eastern, 10, 11, 12, 1. That's 2:30 UK time, 3:30 European time. Thank you, Sylvia. Pray for Jonathan. Thank you. I hope the first week of your new job is going well, Lady Law, as well. I'll never speak to you anymore now. Too busy for me anymore. So that's why I'm glad you stopped in. So, right, let's let's see who the actual attorneys are then, shall we? Which one's this one? Shouldn't. No, 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 no. Jesus, where is it then? That's the one. It's on the top. Um, oh, geez, you have to go that side, didn't it? I'll put myself a little bit higher. Save. Update. Jonathan. Yes. Sylvia, you're all too sweet. I was just relieved one shrinking. Well, also, let's give Jonathan a shout out because Jonathan sorted out my balls. I had a red, like itch, rough thing on my testicle, not testicle, on the scrotum. So you sorted me out, Jonathan. So I'm gonna be pumped for you. So, Dr. Jonathan, let's go. We're all in this together with you, John. And thanks for fixing my scrotum, John. New firm, new procedure and software. Lord, it's made my brain mush. Also, yes, we got to talk. Yes, I miss it. Not heard from you this week at all. So, like, a lot less than usual, then, should we say? Um, and you as well. Sorry, I'm here and there today, getting ready to do my birthday dinner. When's your birthday, John? Monday. They're going through 50 possible due to see who gets a clue schedule for 5 weeks. Yeah. So actually, that's a good point, Sylvia. So I'm not sure if we're going to be seeing that on Monday or not, Sylvia, and all you guys. I'm not sure if we're going to be able to see it. Obviously, we're going to try and see if we can be in court to see it. But if not, then we'll just not much I can do about it. Do you know what I mean? But yeah, hopefully we will see them do something with it. But normally they don't show anything. So I can't promise there'll be a stream on it on Monday, but we'll be streaming straight away as soon as it starts. So, um, yeah, there's probably no stream on Monday, but I'll start it off. And you know what? What we'll do on Monday is we'll just watch something else. I won't start a trial. We'll just watch something else. Um, we won't watch hoof trimming. Don't worry, but we'll watch some car chases or something. If that's the case, and we'll do a small stream. Um, So there'll still be something on Monday. So right, so we got Pablo. Pablo, attorney Pablo Galavis is a partner. So him and his brother own this law firm. So this is who's representing her. They show them going through lots of jurors. I watched it. Okay, so there might be a stream. You might be able to watch it then, Sylvia. Where did you watch it though? Oh, maybe don't tell me right now because people stream sniper. Prior to working as defense attorney, Mr. Gall worked as a prosecutor in the county district attorney office for 27 years. So he used to be a prosecutor, now he's a defense lawyer. He tried over 170 cases to verdict and handled over 35 appellate cases. Although Mr. Galaviz currently focuses practice on criminal defense matters, he and his partner also represent clients in a wide variety of other areas, including juvenile law, family law, landlord and tenant disputes, probate law. My wife is buying me a £3 whole octopus. Jesus, I need a bit of steak and goat burger meat if I can make octopus on one or the other. I'll be honest with you, Jonathan. I mean the bison, or whatever you call a steak. Okay, the rest of it, no, thank you. Happy birthday, Jonathan. Whatever your birthday is, yes, I'll go. Look, okay. Oops. Only day of the year she lets me bring giant slimy octopus into the house and stick it in the pans. Jesus. That sounds disgusting. Yes, it does. Hi, Christine. Hope you're well, Christine. Happy birthday, Jonathan. They're from a fresh import market. They're really, really good, especially compared to like some cheap Chinese restaurant. Octopus, though, no. Hello, Christine. I'd go for the Visine. Visine. Well, so when is your birthday, you muppet? We've asked you about 10 times now. Right. That's his brother then. So yeah, so he's got 27 years of handling civil and criminal prosecution, and now he's on the defense side. So he has got a lot of knowledge about prosecution, which is good. Um, so he seems he's going to be quite solid, I reckon. I mean, um, what was I saying? When is your birthday? When? What day? So that's one of them. The next one then is the female. Present, share screen. Oh, it's not live though. Oh, yes, no. No. So Donna Kutchler is the other one. Let me just move myself again. Date. So let's see, Charles. It's okay. That's how I know about Monday. That's fine. I mean, that's fine. Thanks all. I hate this time of year, so this is like the one day. That's fine. But what we'll do is on Monday we'll try it as that because they might get it done in the morning and then in the afternoon we might just start the trial. So we'll see. We will see. Right. So Donna was born and raised in Wisconsin. After raising a family, she returned to college and graduated summa cum. You see, why do you have to say cum? Because that gets me going. Ladies Orgy as well. So summa cum laude from Concordia University in 1993. She graduated from the University of Wisconsin Law School in 1995. Since her admission to Wisconsin Bar, she has practiced law in Wisconsin. Her son and law partner, Anthony Cotton, joined the firm in 2005. The attorneys at Kutchler and Cotton specialize in all types of criminal defense. Also, it's a mother and son. Oh, that's nice. Criminal defense. The firm has handled many high-profile and difficult cases. Donna specializes in serious state felonies and, in particular, sex crimes and child abuse, including shaken baby or abusive head trauma allegations. Fine. Recently, the Wisconsin Association of Criminal Defense Lawyers honored attorney Donna Kutchler. They named an award after her called the Kutchler Nicholson and Stilling Award. Okay, that's nice. Attorney Kutchler has successfully argued and won a major federal drug case in the 7th District, Court District. Fine. I mean, cool. Donna has been successful in numerous jury trials. Yeah, cool. If you want an attorney that will pay attention to your case, who is willing to invest the time and energy into your defense, and who has an outstanding reputation, please give Donna a call or email her at donna@kutchlercotton.com. Fine. And then the prosecutor for this case is this one. Abby Nicoli. So Abby Nicoli, she's quite pretty. She's a deputy district attorney for WAUKESHA County District. So she started off as a legal intern in May 2012. Education. Okay, sorry. University of Wisconsin-Madison. She got a bachelor of science in political science and government. Then Doctor of Law, JD, 2010, 2013, University of Wisconsin Law School. So she came out. Well, she started going as a legal intern. Then she's basically been in the same, yeah, WAUKESHA County. So she was a when she graduated, she was a special prosecutor, district attorney, courtesy district attorney for 6 months. Then she became the assistant district attorney for 9 years and 10 months, 10 years basically, and now she is the deputy district attorney for the last 9 months. So this is her case. I'll say she's very pretty. Well, she looks pretty there, but um, can't really. Yeah, I think she's. From what I can see, she's pretty. So right, so that's her. I was at school with a girl in prison for shaking me. Oh no! Nobody's surprised she hit another girl in the head with a rock and gave her. Oh Jesus, Jonathan, you just live. Right, and this is the judge. The judge. I think everyone loves this judge, don't they? I think everyone loves this judge. Um, do, 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 do. Jesus. Now so let's go. Right. So Jennifer, she's born in 1970. She's a bit of a cougar. She's certainly from Wisconsin. Born Jennifer Evans in 1970, attended WAUKESHA South High School, graduated in 1988 during her childhood. Okay. She's married to Brian Doro, a former Dean of Criminal Justice at WAUKESHA County Technical College. During the Trump administration, he was named. So during Trump, he was named the Assistant Secretary of Homeland Security. Okay, Doro considers herself a devout Christian. She began working for the WAUKESHA District Attorney in 1986. Okay. So she appointed the Wisconsin Circuit Court Judge in 2011 by Governor Scott Walker to replace Judge Mark Gundrum, who had been elevated to the Court of Appeals. She took office in February 2012. 2012 and 2018, Doro ran unopposed for re-election to the office. Doro was selected as Chief Judge for the 3rd District in 2017 for a 2-year term and was retained in that position for 2019 and 2021. Fine. In February 2022, Judge Doro was selected presiding judge for the WAUKESHA Christmas Parade attack. Oh, that was the Brooks one, yeah. And then Wisconsin's court candidacy for Judge Ron announced her candidacy for the Wisconsin Supreme Court. In a candidacy announcement, Doro cited fan mail she had received, claiming large number of voters asked her to run for office, and claimed months before the allegation that her 9-year-old son was an active drug dealer. She was She was hit with the allegation that her 19-year-old son was an active drug dealer in Milwaukee and that she had been aware of his activities. The information was revealed after the fentanyl overdose death of a University of Wisconsin Milwaukee student, Cade Reddington, who had been a frequent customer of Dorrow's son, Dana Kelly and Janelle. So she came third, basically, in that race. Cash bail during her time on the. Okay, we don't need that. So she's very experienced. Uh, nah, she's pretty, but she's not that good a judge. Oh, is she not? I just thought she was from the Brooks one. I've no idea who she is. I didn't watch Brooks, so couldn't tell you. So I've got no opinions on it because I've never seen it. All right, then we have now got case document, the Kurczewski complaint document. Right, so that was just a little bit to get to this place. So I rushed through it a little bit. But let me. Oh, need to drink some coffee and everything. Let me just check one thing before we get started. That's off good. Ba-ba-ba-ba. Yeah, yeah. Rock your body. Yeah, yeah. Rock your body. Rock your body right. Du, du, du. All right. Just checking this. And then we'll get on to it. Whoopee, 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 whoopee. Whoopee, 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 whoop. Ho, 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 ho. Gravely is Kenosha, yes. Janice, I beg to differ. That one's got nervous steel to deal with D. Brooks as she did. Cool. I don't know. She worked in Waukesha Prosecutor under Gravely. I think that's fair. Jonathan, what is Jungle Gyms? Too many. Thanks, I was confused. Too many trials. Best international import market ever. Far cry from beginner. Okay. Okay, we'll see. Anyway, we'll see, guys. So this is a criminal complaint. Um, what do you think of it? I can't bloody see it. I know. I'll make you see it now. Um, no, I'm not watching Maya. I've not watched any of it. Right, let me just go up here then because I'll go on the top right now because update the hour. Hmm. Bit of coffee, cold coffee, and water. This is like 13 pages. Sue is one of my favorites. Who's Sue? Sue Wolper, sorry, prosecutor. I'm with you. I watched the first day but didn't stick with it. Yeah, Josie's been following it. Yes, she has. Yeah, I had you after you said it. I was like, I looked up Sue Wolper. Yeah, right. So this is the criminal complaint. State of Wisconsin versus Jessy Kurczewski. So she, okay, female, white, hazel color, eyes, brown hair, 5'2", 110 pounds. The undersigned of the oh, Right. Again, sorry for butchering these names. I mean no disrespect to it. No disrespect. I hope you know that. It's quite the case. Defense is going now. That's always my favorite part. Oh yeah. Oh yeah. Right. We know the three counts. They are first degree intentional homicide, theft, movable property. Didn't say what there. And then that is over $10,000. And then the next one is between over 10,000, between 10,000 and $100,000 theft, movable property. Probable cause, right? What? Probable cause and praise that the defendant be dealt with according to law. That the basis for complaints charge of such offences, if complainant bases this complaint upon his review of the investigative report of various personnel of the WAUKESHA County Sheriff's Department, all of whom are believed to be truthful and reliable in the instance. Report of Deputy Jesus. Apologies. Mix. Report of Deputy Migshk. Mix. Mix. Misk. Mix. Reports of Deputy indicate that on Wednesday, October 3rd, 2018, he was dispatched to Meadowgrass Circle approximately 4:55 p.m. Central Time when a caller, Jessy Kurczewski, is Jonathan going? Thanks, Jonathan. See you later, John. Cool. See you later, bud. Victim A was not conscious and not breathing. Upon arrival, deputy noticed a pale, unconscious female subject, later identified as Victim A, lying in a recliner in the living room. The deputy indicated he noticed a large amount of crushed medication on her chest and a plate directly to the left of her with a large amount of what appeared to be crushed up medication still on the plate. Deputy Misk further noted a large number of prescription medication bottles on the table. Deputy Misk further noted a large number of prescription medication bottles on the table on either side of her. Pewaukee fire personnel are also responded and confirmed Victim A to be deceased. Based on initial observations, investigators believed this could have been a drug overdose. The report of Deputy Mishk further indicated speaking to a neighbour of Victim A identified as Witness A, who advised that she had visited Victim A in hospital on the preceding Saturday or Sunday, so the weekend before. Witness A stated after visiting Victim A in hospital. So Witness A is Jessy, fine. Stated after visiting Victim A in hospital, Victim A was released from the hospital the next day. Once Victim A was at home, Witness A advised she received a phone call from Victim A, stating Victim A had fallen inside of her home and could not get her. Witness A indicated she and what? So Witness A is not Jessy. Sorry, my apologize. Witness A uh, Witness A indicated she and Kurczewski responded to Victim A's address and assisted victim A off the floor. Witness A indicated she did not believe victim A was suicidal and had never been given the impression that victim A was suicidal. The reports of Deputy Mick further indicate additional investigation that day revealed that Kurczewski and had keys for the residence due to providing recent care for victim A. Kurczewski further advised that she was the only one who provided care for victim A, and Kurczewski was unaware of any family of victim A. Siri, I thought you said I will always have fond memories of box farts. Okay. The reports of further indicate additional investigation that day revealed that Kurczewski had keys right to. The reports of Deputy Jacoby indicate obtaining a statement from Kurczewski on October 3rd, 2018, in which Kurczewski indicated she checks in on victim A 2 to 3 times daily to take care of her. Kurczewski stated victim A was released from the hospital on Friday, September 28, 2018. According to Kurczewski at the time, the hospital wanted victim A to stay in as an inpatient for rehabilitation, but victim A refused. Speaking of Vox, Ferret is trying to get out until sentencing. It's been decided. Yeah, what was decided then, Sylvia? I know he was there yesterday, but I don't know what was decided. Thanks, Thierry. That's interesting, Sylvia. Um, yeah, I know the judge was going to think about it, Sylvia. I don't know if he's come back with um, anything. I don't know. He looked rough in court, mind. According to Kurowski, victim A was supposed to, right, okay. Kurowski also advised that she believed victim A's behaviour throughout the week was odd, including throwing out bills and stating that the hospital won't get her money. Kurowski stated victim A's pills were off when Kurowski checked them, which included having either too many pills or not enough pills. It had been decided, yeah, I thought so, yeah. I thought there was, I thought, because there was no, the way you wrote it, it's been decided. I was like, oh, what's been decided? Because I know they were just thinking about it. Um, I don't think he will get it, mind. Also, isn't he better off just being in jail for a little bit longer? Better than going to prison. Check the according to Kurowski, victim A kept assuring her where victim A's important papers were and was repeatedly telling Kurowski what she wanted done with her cats, informing Kurowski that she did not want to go into a nursing home. Kurowski stated that victim A was constantly worrying if she would end up having to leave her home for medical reasons. Kurowski indicated she believed there was a possibility victim A was suicidal, but also slated she believed victim A really loved her cats, often worried about them and wouldn't want to leave them behind. Kurowski again reiterated that victim A had no family and didn't really have any contact with anyone besides Kurowski herself. Kurowski indicated she was a family friend of victim A and also the power of attorney for victim A. Jesus. This woman's all the power. The report of Deputy too many pills, not enough pills. So family had to take over parents' meds, go and fill pill boxes, but pull extras away. So I ferreted maybe out. Oh, so he's out. Okay, Katie, thanks for letting us know. So it looks like Ferret to go out then, Sylvia. I don't know why he wants to get out though. It's only like what, a couple of weeks before he gets sentenced, or a week or something. He was shaking and unshaven. He didn't look too good. That's always a sign if he can leave his box. I see cash. So it's interesting because Katie, you see it, the cash bond's been posted. So he's probably out then. So Sylvia, I imagine he's out, just the judge hasn't announced the if that's the case. Okay, there's that, right. Oh, I'll go text my niece. She's been elected to something. So I need to text her, say well done. Even though I don't know what it is she's got elected to. Um, Llongyfarchiadau, tiro. Mangi. Fydd. Okay, so right, let's get back to it. We don't need to go here now. Back to StreamYard. Right. Okay. Oh, thanks. He has business to take care of before jail. Yeah, maybe. How long is he going to go for? Leaving. I will post pictures of food when it's done. Cool. Please do it. So like 50 centimeters or more. Jesus. It's going to try so I may get to stay in the chat. Oh, great, Jonathan. They all do though. Yeah. Right. So reports of Deputy S indicate that on December 19th, 2018, she met with witness C, who stated victim A was a good friend of his. There's just too many witnesses, and he stated that he did not believe her death was a drug overdose, but believed that Jennifer Flower, the mother of Kurczewski, and Jessy Kurczewski were involved in the. Oh, right. Oh, so there's someone else involved here then. So the mother of Kurczewski, that's a new player we didn't know of. Hang on. Oh, just gotta answer the door for a second. 2 secs. Yeah, ma ben WhatsApp so. Oh, boys back. He offered to give a passport and have tether when they were arguing for him. Kroski's family were receiving expensive gifts. Yeah, from yeah. It said in the news article we read earlier on that she was buying expensive gifts and stuff. So right. So but this is first Jennifer Flower. So you remember that name now, Jennifer Flower. I mean that's an interesting one then. So she's a player in this. Um involved in the death. With the C state that he has known victim A for a long time and does not believe victim A would intentionally or unintentionally overdose. He believed Flower and Kurczewski were somehow involved based on the fact that they entered victim A's life, lived in her home, used her things, and then, after death, they were selling her property and using her Jeep, which witness C believed was supposed to go to victim A's nephew. Oh. So this is interesting. So the victim A's nephew was supposed to get the car. This is why the family was up in arms then, probably. Now we see it. The reports of the victim beside casinos gifted. Yes. The reports of Detective Cole indicated that on January 24, 2019, he met with witness B. Witness B stated he contacted the WAUKESHA County Medical Examiner's Office inquiring about the death of his cousin. Victim A, Witness B indicated he had concerns about the circumstances of Victim A's death. Witness B stated that Victim A was his cousin and that Victim A was somewhat close with Witness B's mother, who is deceased. Witness B found it suspicious that Victim A would leave her entire estate to Jessy Kurczewski. Witness B stated he did a CCAP check on Kurczewski and noticed she had several convictions for forgery and fraud. Oh, she's got priors. Okay. Witness B wanted to make sure that the will filed in probate was authentic and wanted um, to make sure there was nothing suspicious about the death of victim A in the medical examiner's autopsy report. The report of Detective Cole further indicated that in January 2019 he was contacted by WAUKESHA County Medical Examiner Dr. Linda Biedrewski, who advised that toxicology results from the autopsy of victim A showed that victim A had a fatal dose of tetrahydrozole in her system. You can all see that. You can all see that. So not just Krowski's family, I mean, but it should all come in. Cool, cool, cool. This will be interesting. Yes, I think it's going to be interesting. There's more layers in than I thought. So I've always said if this is a good trial, we give credit to Sarah P. If it's a bad trial, we, you know, we blame Sarah P. So it's looking good so far, Sarah P. Doctor System Detective noted tetrazoline is a main ingredient in eye drops. Dr. Bizescu advised that there should not be any tetrazoline in someone's blood, but that victim may have 160 ng, what's ng, I'm not sure, per milliliter of tetrahydrozoline in her blood. Dr. Bidrisky did advise that freaking Nora tetrahydrozoline could be considered poisonous to the human body, and it would be impossible to have that level of tetrahydrozoline in the blood just by using it in the eyes. Reports of Detective Cole indicate that after that meeting, the investigation was reopened and continued. Your complaint further noted that in an autopsy protocol completed by Dr. Biedrowski and in an attached letter dated September 27th, 2019, Dr. Biedrowski listed the cause of victim A's death as tetrahydrozoline poisoning and concluded that the manner of victim A's death was a homicide, not a suicide or an accident. Your complaint is further aware that your complainant is further aware that on March 9th, 2019, Detective Cole and Hop met with Kurczewski and her mother, Jennifer Flower, at the WAUKESHA County Sheriff's Department. Kurczewski indicated she had been calling the medical examiner's office multiple times asking about the toxicology results for victim A and showed a great deal of interest and curiosity in those toxicology results. Kurczewski described many medical ailments that victim A had prior to her death and told the detectives how frustrating it was that doctors could never diagnose or assist victim A with her ailments. Kurczewski questioned whether victim A died of medical reasons or whether the death was a suicide. The toxicology results were not shared with Kurczewski at that time. Not all elderly handle getting sick and old well, spending large chunks of money to have fun and gifts galore while they still can. Been getting familiar with Dan Markle case, can't wait for Adolescence trial. When's that? I don't even know when that is. Crosby said she became Victim A's caregiver because Flower was busy and stated she had been at the residence every other day for the last 6 months of Victim A's life, but in the 2 weeks prior to the death, Kurczewski would be at the residence twice a day assisting Victim A. That starts Monday as well. Jesus. So you got Melly, this, and Adelson's trial. That Markle, wasn't he that was a famous one, wasn't it? But he died, didn't he? And it was it his his wife's brother or something that did it? Crosby said she became Victim A's caregiver because Victim A Crosby claims that hospital staff and doctors were so concerned about Victim A that they placed cams in the hospital room. Crosby talked about Victim A not taking her medications appropriately. Um, then she was in hospital not getting her Xanax. Victim made Kurczewski go to the residence to bring the Xanax back to the hospital, even though Victim A wasn't supposed to have it there. Kurczewski stated that towards the end of her life, Victim A stopped allowing anyone else in her life to see her. That's when that she was embarrassed and wouldn't even want friends to visit or know when Victim A was hospitalized. Um, then Caitlin Armstrong, 30, I don't know who Caitlin Armstrong is. Due Reflection Monday. I've never heard. I think Dan Markle I've heard of, but I don't know anybody else in it. But I think it's just quite a straightforward case, isn't it? From what I understood. Kurczewski spoke about how Victim A turned into a different person towards the end of her life based on these medical ailments and wouldn't let others see her anymore. During the discussion, Flower offered that she believed the death was a suicide, at which point Kurczewski indicated Victim A was sick of being sick and having no answers. The reports of Detective Toole indicated on July 9th, 2019, he spoke to Witness D, who advised that he and his girlfriend, Jessy Kurczewski, Witness D, right, had lived together for approximately a year and one half. Witness D, so the boyfriend of Kurczewski, Jessy, stated that Kurczewski could see Victim A approximately 1 to 2 times a month going over there and smoking cigarettes. He further stated Kurczewski and Victim A would talk every day on the phone. Kurczewski would help with Victim A's shopping, and according to Witness D, then when Victim A got sick, Kurczewski would pay the bills. Witness D indicated he was advised by Kurczewski that Victim A had become very sick and was in a coma for approximately 5 months at Frodert Hospital before she passed away. He indicated he had never met Victim A and never saw any mail or applications for credit cards at his house, but believed that Kurczewski was in control of a postal office box in Hales Corner, where Kurczewski would pick up Victim A's mail. Witness D again stated Kurczewski spent more time with Victim A near the end of Victim A's life while Victim A was in a coma, and stated that Kurczewski then visited Victim A quite often, approximately 2 to 3 times a week. The investigation revealed that Victim A was never in a coma or hospitalized for a 5 month period of time at Frodert prior to the death, directly contrary to what Kurczewski told Witness D. In the Markle case, Adelson's co-defendant. Yeah, there we are. There we are. No, it was a murder fight. Yeah, it was the brother-in-law hired the gunmen, I should say. I've seen clips of his story. I just thought I thought they were all in jail, to be quite honest with you. I thought it was quite a slam dunk case from what I read. So that's why I've never had interest in it. Um, The reports of Detective Toole further indicate that Witness D stated that Kurczewski had power of attorney for health care over victim A and was the executed victim A's will. Witness D stated Kurczewski earned approximately $20 an hour or less at a job at the dental office. Yet Witness D stated that in their free time they went to Potawatomi Casino, probably 2 times a month on average, and spent roughly $500 a night per person. Witness D stated that it was hit or miss as far as their winnings, but indicated approximately a year and 1.5 ago he won $70,000. Witness D stated that Kurczewski actually claimed the $70,000 and put it on her taxes. He indicated later that they were both sitting at the machine and split the money. He said 20,000 was put into savings account for Kurczewski for taxes and he got 20,000. He said he paid off 16,000 credit card debt with the money. Um, yeah, that's the one. They still want to go get a few more players. Okay, fair enough. Fair enough. Yeah, I only saw the two gunmen and the brother-in-law, so fair enough. Additional interview was conducted with Witness D on July 16, 2019, in which Witness D indicated that Kurczewski had actually provided Witness D with information leading him to believe that victim A had been hospitalized and in a coma for approximately 4 to 5 months prior to her death. Until Kurczewski shared information that victim A was in a coma, she had not mentioned much about victim A's health. On October 3rd, 2018, Witness D stated Kurczewski sent him a text message later in the morning about victim A dying and stated that she was going to go to the hospital. He indicated he remembered that he was at work at the time. That was not consistent with when Kurczewski actually called 911. When Witness D saw Kurczewski that evening, she appeared to be somewhat distraught and crying. However, due to victim A having been hospitalized and in a coma for months, it was somewhat expected that victim A would pass away at some point. Witness D believes that victim A's cause of death was related to the coma and the coma she was in approximately 4 to 5 months prior to her passing. Witness D also provided information. Jesus, this is what are we on? We've got 13 pages of this. I don't think you guys want me to go through all this, do you? Jesus. Provide information related to Kurczewski being claimed that she poisoned with Visine. He said he looked back at the exact date of the incident was Saturday, January 12th, 2019. Witness D stated that Kurczewski had gone out with a few friends to see a Rebel Grace concert at Pistol Pete's. Witness D recalls um, living Potawatomi County in Oklahoma, pronounce the same, spelled different. I live in Potawatomi County. Jesus. Jesus. Witness D recalls being irritated because when she came home that night, she was a little loud while making herself some food. He believes it may have been around 1 a.m. and he was trying to sleep. Witness D stated he asked Kurczewski to keep it down. He thought she may have been a little buzzed because of all the noise she was making. At some point, she told him she did not feel well. He did not recall her throwing up or anything. like that, but she was up for some time. Uh, She got in a car and said she drove herself to the hospital around 6 a.m. She drove herself home at approximately 9 a.m. Kurczewski told Witness D that she went to the doctors and that they tested her, and she said that they told her that she had been drugged with Visine. She further stated to him that the police had been notified. Kurczewski stated that the doctor was required to notify the police due to believing she had been drugged. When Witness D contacted friends she had been out with, he was inquiring if anyone had been switching drinks. No one indicated seen anything suspicious or switching drinks. He said in the back of his mind he could not see any of his friends doing such a thing. Kurczewski did not talk about any follow up with the police, and after that day, the issue was done and never talked about again. Love these Indian names. Talk about love. I love this woman. Pota, pot a wa tomi. Is that like a sexual thing? Pot a wa tomi. Stick. It's like stick it to me. Stick the D to me. Pota wa tomi. Potawatomi. Potawatomi. That's the best I can do. Potawatomi in Oklahoma. Theory, my dad was Broken Arrow and my mum was from Red Fork. Jesus, these names. Great name. Upon witness D learning that victim A was never hospitalized long term in a coma, he was in shock. So now that I know that Lady Law is here, I have to read it out because she's working and listening. So I can read it out because she's not looking at the screen. Witness D further stated he was once told by Kurczewski that victim A had a do not resuscitate request in her will, and that according to Kurczewski, approximately 4 to 5 weeks before victim A's death, the hospital resuscitated victim A against her wishes. Kurczewski stated to Witness D that Kurczewski contacted an attorney regarding the issue, and the attorney was taking care of it. These attorneys. Witness D then indicated that Kurczewski had a lot of elaborate stories. Witness D stated that because he believed victim A was hospitalized in a coma and believed that all of the what Kurczewski had said about it was true, he actually commended Kurczewski for taking care of a victim A and told Kurczewski that victim A was lucky to have Kurczewski and all that Kurczewski did for her. So Potawatomi is you got long distance ties to. Okay, Jan, that's interesting. I live near the Kickapoo. 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 Love it. Witness D's ex-wife, Witness E, thought that Krauski's gift giving was a little weird. She said that Krauski would give her gifts of $100 spa gift certificates. She felt it was odd behavior and believed that Krauski had to be charging all these expensive gifts. She believed that Krauski was a habitual spender and must have had large amounts of credit card debt. Witness E made reference to Christmas gifts provided to her children, such as laptops and Game Boys. She was not sure where the money was coming from to purchase such large gifts. Whether E questioned Witness E questioned if the elaborate gifts were all from victim A's accounts. She felt this would have make the most sense to her, stating that witness D makes normal money and Kurczewski wouldn't be working. She felt as though Kurczewski was ex- excessively using credit cards for the purchases. There are many tribes people have now even I've never even heard of. Yeah. Haiti, Oklahoma's Unites. Um, Witness D and Witness C. I'm sorry, guys. I'm butchering all this. I am sorry. I do apologize. I don't really care that much, but still, I do apologize. I didn't realize this would go on for so long. And I'm afraid if I bore you, I'm sorry. I've literally got one more video to play after this, and then we're done. So don't worry. But I think it's interesting that we get through some of this stuff. Do you know what I mean? I know you can read it for yourselves, but you know, Witness D and Witness D's daughter, Witness F, also felt as though Kurczewski's gift giving was excessive. She stated that um, because she was older, she would ask Kurczewski where these gifts were coming from. Witness F provided an example of Kurczewski um, ability to spend money and how to arrange when Witness F was studying abroad. While she was studying in Thailand, Kurczewski had offered to purchase plane tickets for B, Witness E to go to Thailand to be with Witness F. Witness F stated that they were not used to gift, that they were not used to gifts of such nature. Many Okies throughout different channels. Okay, how many neighbors are? Right, Witness F also stated that Kurczewski made mention of a hospital malpractice issue. She asked if Kurczewski was going to use she asked if Kurczewski was going to sue the hospital, to which Kurczewski stated that they had settled out of court by clearing all of victim A's hospital fees. Witness E also provided information regarding what Kurczewski had shared with her. Witness E stated they would see each other at the children's sporting events, and Kurczewski told them that victim A was in a coma. According to victim E, it appeared that Kurczewski was telling multiple people different stories, different variations of the story. Kurczewski also told um, talked to the detective. Each incident took place at WAUKESHA County Sheriff Department, and Kurczewski was Mirandized each time. Each time Kurczewski waived her Miranda rights and indicated she wished to talk with Detective Hope and whatever. The detective was presented for the interview that day. On July 9th, 2019, Kurczewski again offered frustration. There was not any answer yet about how Victim A died, whether she just wants the payouts. She can't get paid out. Yeah, she wants the payouts. On Joyce. I'm a little confused. Lady Law, I'm a little confused. Was alleged malpractice settlement to cover up fake coma? Something separate, I think. Something separate. Yeah, so I'm not sure. We will find out, but I think it's something separate, to be quite honest with you. No, Kurczewski said there was no official payment arrangement with Victim A for her caregiving, but stated Victim A would give her checks or a credit card to use or cover Kurczewski and Flowers' rental car payments. Kurczewski, Kurczewski stated Victim A was always helping everyone financially. Right, hang on. Um, Jesus, I need to splash my face because this reading is making me tired. Some water on my. Oh, okay, that's. I wonder. It's surprising that how much reading takes it out of you. Jesus. Detective shared with Krowski the anomaly in toxicology report results with geez, begins to explain how frequently victim A used eye drops, saying she was known for eye drops and that uh, she purchased them in great volume. Si- Sifting through all the stories of the defendant to different people would take a long time. Yes, definitely take a long time. CG, alright, put away your toys. ACG is here. Welcome, ACG. Hope you're well. We're just going through the trial for Monday, but I'm getting tired now. I'm literally, I could be reading and fall asleep here. Uh, she was known for eye drops. Fine. Victim A would buy 6 bottles at a time. Anytime she was time, would make Kurowski buy her bottles all the time as well, even bringing them into the hospital. Okay. Kurowski talked about how Victim A would drink alcohol to excess, and she was abusing her medications and become very impaired at times. Krosky then discussed that 3 times Victim A told her, "Don't want to do this anymore," and suggested um, another CG. Hello, working from home today. Happy days. Happy days. Jesus, I'm struggling. Attempted to tell Krosky that the medical examiner thinks that someone poisoned Victim A because there was no eye drop bottles near Victim A, and Krosky tells detectives how they were eye drop bottles all over the house. Detective then Well, how I was hard to. The detectives tell Krowski that the medical examiner thinks that the pills at the scene near victim A were staged. They were once there, and that didn't stop anything. Jesus. Okay. Well, I'm struggling. You would think that reading something like this would be fine, but I'm generally struggling with it. I'm falling asleep here reading the bloody thing. Um, she obviously denies it. Let's a paraphrase. During the interview, Kowski again denies ever hearing of someone dying from Visine poisoning. Okay. She then says that she's seen Victor May drink vodka with Visine and stuff like that, as we know anyway. Um, and she says that Victor May has been trying to kill herself with Visine in vodka. During the interview in July 11th, 2019. Kurowski continued. I think she said it, Sylvia. I think she said I should put six in. Uh, so here we go. About for an hour prior. Hang on. Victor May told Kurowski that she wanted that bottle. Um, so here we go. An hour later, Kurowski says that the water bottle in the photograph from the scene of Victor May's death had six bottles of Visine in it. Kurowski said that Victor May told her he had six bottles of Visine in it, and when Victor May told Kurowski that she wanted the bottle, Kurowski brought it to her, knowing that it was Visine in it. So yeah, so that's how the, she says herself there was six in there. In interview July 12th, 2019, Krauke tells detective that she has items in storage unit in someone else's name, like recordings of victim A's wishes, partial firearm, dated Visine bottles, and papers of victim A signed somewhere, but she won't release the items until she's ready. Oh, in the interview on July 16th, 2019, Kurowski assures detectives she could find the buried items if they let her go to the park herself. Kurowski was ultimately allowed to watch detectives at White Knoll Park via video call so she could direct them to where she allegedly buried. Right, so victim A was sitting right there. Um, Kowski also indicated that any financial transactions that were done were with victim A's consent and stated she was absolutely certain. She never wrote herself a check from victim A's account and only ever signed victim A's name on a check if it was for a bill and victim A was sitting right there. Kowski claimed that the victim A was in an interview on July 13th and 19th. That happens, right? Reports of Detective Rothstein indicates that on April 26, 2010, he received a report from the Forest County Potawatomi community regarding the usage of Butterwanomi Bingo Casino, Firekeepers Club, and registered to Jessy Kurczewski's relieving the from July 1st, 2011, at a total loss of $40,000.66. Jesus. So she spent a lot of money. Yes, the medicated eye drops are basically poison. Also, folks go with basic lean. Fine. This was supposed to be trial November 20th. Or why was it just March? I have no idea. No, I don't know, Sylvia. I don't know. Did the victim not have any family? Yes. So a jeep was supposed to go to her nephew, but it never did. I think she's got family, just that this one was in full control of everything. So that's why. Jennifer Flowers was interviewed in 2010 as part of the above investigation. I was obviously upset with Kurczewski and stated Jessy had been ruining the entire family's lives. Flower stated that she has reached the end of her rope in dealing with Jessy's antics. She stated she was missing a social security card, identification. Kurczewski was, says, it's how she's used the money and stuff, it says then. So they come to total fraud, believe committed approximately 290,000, 132,000 nearly, sorry, 130,000 just over. Financial records also show continue spending and gambling. Okay, so that's the gist of it. We know what the so why wasn't family checking and allowing an outside to have full control? I know why it happens as I've seen it a few times in my work. No idea, Terry. I mean, it'll all come out on Monday or next week onwards, obviously. But that's the gist of it, of where it all comes from. There's a few lies in there. Right. This is her in court. Right. So this is her.
Attorney Gallivis and Attorney Kukler.
So this she appeared in court. When was this? 6 days ago. So she has appeared in court, right, for bail, but it's always been dismissed. So she's in prison. So she was her bail requests have always been denied twice, I believe now. Update layouts. They said this trial has lots of exhibits and lots of financial stuff, which I hope they use the mic. I mean, yes. Let's have a look.
Sit here with our client, Jessy Kurczewski, sitting at the end in custody. Good morning, Judge.
Right, good morning. We are here today for the juror questionnaire conference. Has the state complied with victim rights? Yes. And just a note for everyone, the media is present today.
Sylvia, this is probably what you were talking about. Perry, you and me Judge, I'd love to fuck. Yes, Perry.
Okay, they are recording, so if anyone is, just be mindful of that, that cameras are capturing this and may capture anyone coming and going in the courtroom while court is in session. There is the trial administration order, and it does apply to today to the extent that it can be complied with. Obviously, that trial administration order contemplates a little bit different setup with microphones and cameras, but other than that, it would apply. I know the parties have met and conferred. I have some documents related to that in terms of there are some stipulated strikes for cause. I appreciate the parties reaching agreement on that.
I am. I'm literally there. 2 hours. I am there. I think I deserve that one. I'm there, Sarah. You don't have to give up. I'm there. 155. Close enough.
There is a request from the defense. I believe it's 44 individual jurors, and then a request from the state, another 4. Please be mindful, since this is being recorded, and there is the order regarding the number of juries. I believe that's document 162, to only refer to the jurors by one of their numbers, and not. It's probably best if we rely upon their pool number.
115, yeah. But I mean, I'm just going to give myself a little bit of credit there. Like 5 minutes away. And also, it's Perry's fault putting that up. I blame Perry. If he hadn't put that up, I would never have said it. So, Sarah, let's blame Perry on this one.
Madam Clerk, I know you looked at the list more carefully. Which number did the parties utilize most?
Juror ID number.
All right, then we'll switch that and we'll go to the juror ID number when referring to any particular juror. I know the state also had filed a letter indicating that there was a request that I address the following outstanding issues, with the exception of the defense amended witness list. There are a number of items I would call evidentiary, perhaps issues. I had an opportunity to re-listen to the jury status from January of this year, where many of these topics were raised. At that time, the February 13th trial still remained. I'd given an extension of a deadline in terms of addressing any of those things by motion in limine. Nothing was filed by that. I also had done an amended trial order once the trial was adjourned, and no motions have been filed related to these topics. And so I'm not going to make any pretrial rulings as it relates to any of these topics. I will rely on the adversarial process during the trial. And so I'm not saying one way or the other whether something comes in or it doesn't. So I'll just rely upon that and make rulings as need be. There can be certainly many reasons why a party objects or doesn't object. And so given that there are no motions in limine that were filed, that's how I will address the letter from the state. I know I also had referenced in that prior jury status regarding a cautionary instruction regarding Ms. Kurczewski being in custody at times. To date, I have not received any such request. I may, in my own discretion, draft something if I feel it is appropriate, but I'll wait and see how the testimony and evidence comes in, and ultimately if there is a request. It would be something very general from my perspective if the jurors were given some type of a cautionary instruction, something to the effect of, at times there may be reference to Ms. Kurczewski being in custody. Her custodial status at any point in time during the investigation has no bearing on her guilt or innocence and may not be used by the jury in any way, something to that effect. But again, I'll wait and see what the defense does with that. Since it's a single issue related to this amended juror list, it's a second addendum list of defense witnesses. Let's just deal with this initially, and then we'll jump into the jury questionnaire conference.
I just want to listen to it all.
The state requested that I address it, but
this is the
all
last
that is
thing we
listed
watched
on your
today,
letter is an
so
offer of proof. So please tell me what the objection is, or what you're looking for.
Judge, we'd first object because it's untimely. There's been, as the court has already referenced, a series of orders and trial scheduling orders in this case. Adding defense witnesses to this case is the reason that it's not been completed when it was scheduled to be completed in February of this year. And yet we have another new person filed, I think, around 2 p.m. yesterday by the defense. And so we're objecting to that person testifying based on that being a blatant violation of all this court scheduling orders. If the court is unwilling to do that today, we're simply asking for an offer of proof, perhaps a date of birth for this individual, so that we can do what we need to do before the 23rd.
Paragraph 5 of the trial order issued by this court and filed as document 202, filed on April 21 of 2023, said the following: disclosure of lay witnesses has already occurred. Any additional witness named by either party must be filed no later than June 15 of 2023. The naming of any additional lay witnesses beyond June 15, 2023 will only be allowed upon motion for good cause shown. Disclosure of expert witnesses has already occurred. The court has extended the time for the defendant to name an expert in the field of pathology to June 15.
So I always go yellows. This one now. Let's have a look. This one currently is currently it's on green. Right, hang on. I want to test something out. I want to test this out, right? I know you're gonna hate me for it, but let me just test it out. I'm not gonna play this for the next minute, right? I'm gonna press the oh yeah, I always go yellow. Always go yellow. Always. But Sarah's in a bad mood with me now, and it's all because of Perry. So and I've been good recently. I'm gonna see if the ad works. But don't worry, you're not missing anything. Let's wait to see if it works. Some of you do have ads, because that's a good indicator if it came through or not. If it's yellow, let it mellow. I always get yellow, but I'd probably turn yellow after the stream, Perry. Yeah. Happy days to you. Oh, Terry, you didn't skip, did you? That was a quick one. Did you skip it? I don't blame you for skipping it. I try to get people not to skip them. Because then I can, it doesn't give me much, but it helps me out a little bit. I know, Perry. I know. Yeah, no, it's fine, Terry. I know. That's why I'm sticking a minute. 'Cause some people very kindly don't skip it. I can understand why you do skip it, Terry. But if you skip it, we don't get anything for it. But if you watch it to the end, we get whatever, a couple of cents for it. So it's just something. It's same as when you come into the streams. If you skip it, we get nothing for it. But if you watch it, then you get a couple of cents for it. Perry, you don't know me well enough. I read everything. I try usually, but Oklahoma market. No, it's all good. Don't worry. It's fine. I say it's fine. I'm not gonna ask you all to watch stuff. It's just more of a. If you're able to, please don't skip. But I'm not gonna also hold you to it. So it's all good. I love Judge Doro. Hi, Anunia. Welcome. Welcome. Right, everyone's probably back now. What I can tell you is Sarah P's still in a bloody grumpy mood with me, even though I'm still green.
Of 2023. The notice shall include the name of the expert, CV, and summary of the proposed testimony. The naming of any other or additional expert witnesses will only be allowed upon motion for good cause shown. I don't have any motion before me today. I just have this filing. Why should the court even entertain the naming of this witness, Attorney Galaviz? Attorney Kukler, I guess you'll be the one addressing that.
Okay, Judge, in prepping for trial, this is a witness that is in the state's discovery that they provided to us, so it's not a surprise person. I saw the name in reviewing some of the financial records. So it's a person that was involved at one of the banks, and the state does not have him listed on their list, but he was involved in the case. So I've determined that although his testimony would be brief, probably no more than 15 minutes, he does have important information to offer. We can file a motion requesting for good cause and we should do that.
Given the trial order in this case, I'm going to deny the request at this point in time. You indicated you understand you may need to file a motion. I'll wait and see if that motion is filed. But at this time, the witness is not allowed. All right, then let's move on to the jury questionnaire conference. Given the stipulation
Yeah.
of the parties as to a number of the jurors, any objection from the state if I strike those jurors for cause at this time?
I'm sorry, the stipulated
The
list?
stipulated list.
No objection from the state, thank you.
Any objection from the defense?
No.
All right, then the jurors that were indicated on the previous filing as being stipulated to, the court will strike for cause. There were, I believe, 18 were listed. My understanding is one, which is number 9, and document 231 had already been excused.
That's my understanding, Judge.
Our understanding as well.
All right, and there were 2 typos as to numbers. Number 2 should have been 7814, and number 4 should have been 695. You might want to verify that first, but that's my understanding, right, Madam Clerk?
No, I don't think so.
I think it was just a reference to the wrong number.
Yeah, in one case, they used the pool number instead of the juror ID number. So number 2 was stipulated, was listed as 0756, but was corrected to 7814. And then number 4 was corrected from 0852 to 695.
Right, it's just to be consistent that they're all identified by the same number. It's the same person.
I think that's the same for number 17 then.
And
Number 17 should be 6584.
I've not watched that at
Not
all.
on my list, but do you agree with that?
Yes.
All right. Just, I will read them into the record just so it's clear, and then you can tell me. 7403, 7814, 4521.
No.
4521 is number 3. I'm sorry, 4541. I said that wrong. Thank you. See, this is why we have these conferences. 4541 is number 3. 695, 268, 4337, 4450, 4424, 608 was already struck or excused, one of the two. 7227, 5712, 285, 2052, 3207, 4302, 5870, 6584,
I know, yeah.
728. Did I miss anyone? Attorney Nikolai?
Hope you're well.
Attorney Kukler?
No.
All right. All right, then we'll turn next to the request by the state. There are 4.
I'm sorry, Judge, could we just have a minute? We're having trouble finding these numbers that were incorrectly on the list.
So this is all in lead up for Monday. So that's why I want to watch it.
756 will be 7814. So
I know.
pool number 756, but juror ID 7814.
Yes,
Yes,
that's, we agree.
Yes?
Yes.
And then 0852 would be 695.
And we didn't agree to
That's on the list. And then you just confirmed it.
so
695. I agree that's what that number's been changed to.
You have 0852 as number 4.
and
Yes,
The juror ID number is 695.
yes, I agree. That's what the state requested and we agreed to it.
I know.
this is this one.
Abby, do you want to see your email? It's right here. It's on this email.
And then 6382,
Pardon me, Judge?
number 17, should be 6584.
Right.
Right. Yes, that's correct.
Thank you.
Which actually, I think maybe the confusion was the pool number was 655 for that person. Sorry, 955. And then the number instead of the 6382 is 6584. That may be the confusion.
We agree on striking 6584 for the record.
Let's try it a bit faster to see if that makes a difference here.
That's the
You
state's
don't need to
recollection
listen
as well.
to all the numbers and stuff.
6584.
Right, that's a juror ID, the pool number 95. Madam Clerk, how did you come up?
6584, the pool number for that is 969. I have an email that told me that.
Nine- Right, I'm gonna these number stuff. I don't really give a crap about.
Right.
6382 was the state in the defense request for strikes, but the 63.
Self-admitted discriminative thoughts about certain races and sexuality choices. Anthony Cotton recently to represent the juror's brother. And it would not be able to be fair considering, I think that any jury hearing a homicide case is going to know that on a conviction, the person is going to be serving some custody time. I would say that this may not be a request had we been preparing a OWI trial or
Yes. This is what I'm doing a 1.5 now. So we're starting to get into it now. I wasn't going to watch this trial. You're going to watch it now, Thierry. Can see it both ways. Okay, interesting. Interesting. I watched it on 1.75. Well, I'm going to watch it here to see who's being dismissed.
or something of that sort, but the fact that it is a murder charge and that's specifically what this juror cited having trouble with is the basis for our request. She indicated she would feel bad if I had to put someone away in jail.
All right, what's the defense position?
We object to this person being struck at this point. I think it's premature, possibly. I think there could be some further questioning of the person. We don't strike people because they're very religious, number one. That isn't a basis. The person indicates that they may feel bad if I had to put someone away in jail. That's not a basis to remove them from the panel. Probably most people feel bad in some ways, having to deliberate and reach a verdict, but I didn't think that this would qualify.
I'm going to
To
deny.
clarify the record, I was not in any way suggesting that because this woman has religious beliefs, she's not qualified to be a juror, and that was what was suggested.
All right, thank you. I believe the request to strike for cause is premature. First of all, it is not the role of the jury to concern themselves with sentencing issues. There's obviously a jury instruction on that. While perhaps our answer.
This is going to be bitchy. Do you hear that from the deputy district attorney? Woo! This is going to be. There could be fireworks between attorneys, I think, on this.
Would raise an eyebrow as it relates to whether she would have make a decision based on sympathy. I believe further follow-up is required to find out if she has formed any opinions or if she could set that aside. One of the standard questions that this court asks an individual when there is a question that raises a concern would be, are you able to put your feelings or opinions aside and decide this case based solely on the evidence presented and the law as the court defines it for you? And also to reiterate with that juror that they cannot make a decision based on sympathy, and to remind the jurors that they also need to make a decision that does not take into account any the consequences of their verdict is the language of the jury instruction. So I
That's
will
fair.
deny the request as it relates to juror 1073.
That's why I want you here, because of that different opinion. People are going to think of this differently. So it's interesting to me. You see,
Moving next then
interesting.
to juror 1476.
Thanks, Judge.
To me, it
The
doesn't
basis
look
for this
good.
request is that this juror indicated they hired Anthony Cotton recently to represent the juror's brother in an extradition. Given that Anthony Cotton is in the same firm as Attorney Kukler, that was the basis for this request.
And your legal support for exclusion at this time?
That this juror potentially knows one of the parties involved.
You mean one of the attorneys?
Right.
I don't think knowledge alone is sufficient, but what's the defense position?
We don't think this person be struck just because they know somebody in my law firm. It wasn't for, they didn't hire a firm for themselves in any event. It was for some brother's case. I don't personally even remember this case. And I don't think that jurors know somebody in the district attorney's office or know somebody just on its surface. It would be because they are involved with it as a basis to strike.
I think follow-up is needed as it relates to this juror as well. We're somewhat speculating that there would be a bias, if you will, for the well, against the state, or some type of, imputation in a good way to the defense because Attorney Anthony Cotton is the son of Attorney Don Kugler. We don't even know if they've ever met. We don't know at this point if Attorney Kugler herself made any appearances on the case. I think that would change my analysis, but no one's presented me with those facts. Just like the previous juror, I think more follow-up is needed and very specific questions regarding this particular juror's familiarity with the firm of Kugler and Cotton needs to be explored, but nothing at this point rises to the level of any type of bias, objective or subjective. All right, so that'll be denied as well, and that juror shall remain in. All right, then moving on to number 2325. Go ahead.
Thanks, Judge. This individual lives in Milwaukee. Is the basis for our request. The address he provided is on 59th Street in Milwaukee.
Well, that would most likely take them out of criteria. You agree with that, Attorney Kugler?
Yes, absolutely.
All right, so 2325 is struck as not being qualified.
It's
because
interesting,
the juror lives outside of
Thierry.
town.
That's a good perspective.
All right,
I
617.
thought you might enjoy this trial then. You got a lot of experience in this, Thierry.
This
So I thought this might be a trial that you would.
cause concern
really
to the
enjoy.
state because of comments regarding self-admitted discriminative thoughts about certain races and sexuality choices. Out of an abundance of caution, we flagged this person and are asking that they be struck based on that comment. Attorney Pablo Galvez obviously could potentially be the type of person this juror is indicating they discriminate against. And that's really the basis. I guess if the defense objects to that request, I would withdraw it.
Attorney Kugler?
Yeah, I think that we will agree to this one after giving it second thought. We'll agree to this one to be removed.
All right, then based upon the agreement of the parties, I won't stand in the way of that, and juror 6178 is struck. Okay, thank you. That gets us through the state's request. And then Attorney Kugler, will you be addressing the defense strikes for cause?
I can do that.
Yeah.
And again, I have them in numerical order based upon their juror ID number. So do you need a moment to?
Just let me.
High hands for all.
I have
Sorry.
mine in order.
High
by juror number
hands
2.
for y'all.
we should be
497
good.
should be the first one.
I think your first time viewer here. Hands for y'all. I love that. So you're from Texas or that area, Oklahoma, Texas, I presume. But welcome, hands for y'all. As I say, I don't think you've been here before, so very, very welcome to the channel. I'll welcome you. My main mod here, she's grumpy today, so she might not welcome you. I'm joking, she will welcome you. But yeah, thank you for coming in here. It's triggering because of sad things I've seen, including my own family. Yeah, okay. Yeah, okay. I get it. I get it. But I think you could offer us a lot, though. Do you know what I mean? KY jelly. Is that KY jelly? Is that a thing? KY jelly? Is that Kentucky? Is that Kentucky? Hey, Hens, you from the South, lol. Yes, thank you for hosting. It's my first time. Well, welcome. Welcome. You're more than welcome to be here. And I'm glad that you are here. I hope you know this trial. We're going to start streaming it on Monday. We all welcome you. Yes, Kentucky Fried Chicken and a Pizza Hut. McDonald's. There we are. We all welcome you. Yeah, Emma, you're still here. So you've gone, Ems. Here she is, Sarah P. So Sarah P's a little bit grumpy today. Heading for you all. So, just ignore her. Just ignore her. It's all good. I'm joking. She's all right. She's all right. Kentucky. There we are. Because I follow a lot of the college sports and stuff there. So I knew he was roughly there. Cincinnati, Joe Burrow there with the Bengals. Not Will Fries. No, I don't remember his name now. Titans quarterback now. I follow a little bit of the basketball, Kentucky. Welcome, hands for y'all. KY Jelly, let's go, Perry. You and me, Perry, we know. There's beautiful places in KY, yes. Are you as well, then? Yeah, I didn't know you were KY. Let's go, hands for y'all. Right, so this happened last week. We're still watching this. Hopefully, hands for y'all, you can join us for this trial. I missed it, but sold something on Vinted. Oh, I love Vinted. I buy all my tops from Vinted. So Vinted is fantastic. That's where I got all my jerseys for NFL from. Is Vinted. It's cheap as chips. I don't know. I discussed it with you. I don't know how to sell stuff on there. Never lived there, but traveled through many times. I've seen Cincinnati a few times. Cincinnati then is got the the chili, Skyline chili. So Skyline chili with loads of cheese and stuff on it, isn't it? I know it. Oops, lived there. Oh, you've not lived there now. But yeah, Skyline chili, very close. Whoa, what's her name? Basketball. Maddie something. She plays basketball for Kentucky women. She's nice. Anyway, welcome, Hensley,
We're
all.
asking that 497 be struck because this person is a police captain at the Brookfield Police Department and knows all the Waukesha district attorneys.
Have you read State versus Lewis, 156, second, 470?
No, I haven't.
Are you aware that our Supreme Court indicated that police officers, even those with knowledge of other witnesses, that are per se ineligible to serve as jurors? There's an extensive discussion in that case. I think it's directly in point.
In
The
addition-
Constitution and even our statutes really make very clear that exclusion based on groups should not be a basis without more information.
I think you'll have more information.
Right? It's possible.
No, I have more
Oh,
information.
you have, what is the additional information?
The additional information is also that his mother is in hospice for heart and spine care, and he is one of her assistants, and it would be very difficult for him to assist her if he was in a 5-week trial. So given all of those reasons, we ask that the court excuse him.
Just a note on hardship. If I were to exclude everyone who claimed a hardship without questioning further, I would dramatically limit this jury pool. And I don't think that's a basis. This is an obligation that citizens have to serve on a jury. Certainly a hardship could rise to an issue if they're not able to be objective or if they identify some other type of bias. But I think just the identity of a hardship in and of itself is not a basis.
Right. I'll just let you know, Hensley, all right? You've got to watch your phrasing because instantly you said Skyline on 3 ways. Instantly. I'll give you credit. Me and Perry have gone straight away 3 ways. Hey! But we're just dirty-minded. But I don't know what 3 ways is, what you're talking about, but I know what I'm thinking about. So just to let you know, phrasing. But 3 ways. What is 3 ways? Perry, behave. Behave, Perry. Yes, Kentucky abbreviated. There we are, Nunia. We're learning something every day. Wave. I love this judge. First time to ever to hear it, actually. Western part of the states here. Western part, yes. You see, Terry's even dirty-minded. Terry.
To exclude or strike a juror for cause because it does not evidence any type of bias.
Someone
or
said
prejudice
3
on
ways.
the
I'm
part
like,
of the juror.
let's
If there's
go.
any additional law you would want me to consider, please let me know.
Spaghetti chili. Oh.
Anything else on that, Attorney Kugler?
No.
What's the state's response?
We are objecting to
With
the
you.
motion to strike.
Right. I have to pause for a I'm sorry about pausing all the time. I got you chili, spaghetti, and shredded cheese. I got you. I actually saw that. Some people I follow on Barstool were eating that actually. Yeah, I'm sorry. And also, Henry, I am sorry. We're not that bad, but I tell you who is bad. I can't wait to see this judge in the real trial. Yes, I can tell you who is bad. Once this has turned sexual, he comes in. Here he is, Dave, Daddy. I saw a dock where Flag has the highest grade coal seam in the world. It's located on the coast. So, Daddy Dave, welcome, Daddy Dave. Welcome back. Hope you're well. Hope you're well and well you're rested up. Hope you join us as soon as this gets dirty. You're here. Most that travel through think the same. I know. Good. Hello, Dave. Could you imagine having to serve duty where your mother's in hospice? Yeah, that would suck, Tim. You're right. No, you don't have to pause. Thank you. I'm just sometimes I go too far. Morbid sense of humour myself. Happy days. We are. You've not met Jonathan yet. So Jonathan, his birthday's I think today. Once you meet Jonathan, hence for you all gloves are off. That guy is one of the funniest guys I've ever seen in chat, and he says stuff that Jesus, I don't know what he says. So I'm glad you got a sense of humour because you need it in this chat sometimes. Hello, ladies. What about my your 12-incher? I'll watch the trial next week. Love the judge. Thank you, Dave. I love seeing you in trial, so please come and join us. It's a 5-week trial, apparently, but we'd love to have you,
For
Dave.
cause this individual, it's premature, and I think more information would need to be obtained. That's all I'll say about that.
All right, I'll deny the request as to
We
form.
love Daddy Dave. I do have to be careful, don't I, about welcoming people, because not everyone has got a sense of humour. So you're right.
No.
You were right,
looking at the letter.
Thierry. Thankfully,
Is that someone who stipulated to the 285?
thankfully, Henry All's got a sense of humour. Jonathan
yes,
is
it
bomb.
was.
He is the best.
I'm
I'm
looking
not
at your
saying against
letter
everybody
as you're
else, but
listing and realize I started with the second person, but that's because the first person is
he's
what there's a
amazing.
stipulation to. Okay, then let's move on to juror number 629, Attorney Kugler.
I think this person, everyone's got a hardship, so there's no doubt that we are hearing hardship. For many people, this one has a particular hardship because of the employment. It's outlined on page 7. Detrimental to his company, can't reassign all the responsibilities for that amount of time, oversees 14 full-time employees. Just a little bit too much. It's too much for this particular person. We're asked that he be excused for such a long trial.
What's the state's response?
Judge, we're just looking because there's some indication that we had this person was postponed recently by the court already. Nonetheless, we would object because there's not enough information about this individual to strike for cause.
I'll have Madam Clerk reach out to our jury coordinator, Lauren, to find out. They are still on my list and my spreadsheet that I've been working off of. Nonetheless, I'll deny the request to strike for cause. Again, I think we're premature. We don't know anything about this company, whether it's a, is it a 2-man accounting position in America in this company? The person looks like they're in accounting, but they work for I don't know if it's a larger company, a smaller company. We don't know really what the basis of the hardship is other than what's explained in the jury questionnaire. But I think we need to ask this individual more questions and then find out if at that point in time it would be appropriate. But again, I stated this earlier, hardship alone is not going to rise to the level of being struck for cause. Maybe later on in my discretion, but not at this point. So 629 remains.
Yeah. But it's asking a lot. They don't get paid, do they?
All right, 811.
Yes, Your Honor, we have asked that various people who are victims of theft and robbery be struck, given the nature of the case, and this is one of those individuals. That's the basis.
So I think, Dave, from what we read earlier on, her son's messed it up for her a bit, I think, because her son apparently is a known drug dealer. She went for a higher job, but she had to pull out because her son was accused of dealing drugs and that she knew about it. And that was like late last year. So I'm not sure if the Brooks thing would make a difference. She's still got that hanging over it, her son. So I don't know.
Attorney Nicola.
We'll be lodging objections to this series of individuals. There's more than just burglary, robbery, and theft victims that are on this list, and the victim has an absolute right to participate in the criminal justice system as a juror when appropriate. So we'll be lodging this objection to several of these individuals. We simply don't know enough about this juror to strike her for cause at this point.
I would agree. It's premature at this point in time. We don't know anything about the nature of the crime listed by the victim. We don't know if there are, similarities or not. And even so,
That's
I
it.
ask jurors routinely
No,
who come
yeah,
into court with some experience that might touch on one of the.
She lost because of her son, basically. She came third. She was a favourite. She should have won it, but she came third in the end because it came out that her son was selling drugs. So, I believe some states require their employees be paid, but others don't. Oh, okay, so in the UK, you get paid. Your employer pays you. So that's why it's strange to me that in some states you don't get paid. 19, Dave, 19. But thanks for that, Henry All. Thanks for that insight. 19 he was at the time, so I'm probably 20 now. It's probably gone now, Dave, but That might be a
the crimes
reason.
that are charged. Are you able to put aside your feelings or your opinion or even your experience and decide the case based solely on the evidence presented in the law as the court defines it for you? I owe it to all of those potential jurors to ask them that question to find out whether they have any type of bias. But every juror comes into the courtroom presumed to be fair and impartial, and nothing about just being identified as a victim of a crime.
I'll be back now, 2
without more.
seconds.
So 811 is denied and will remain in the pool. Juror 870 then?
Thank you. 870 has indicated that her mother recently died, and that causes her to have problems sitting on this case. In addition, the person has sleep apnea, is unable to concentrate in the afternoons, and sometimes falls asleep sitting up. Somebody like that, we need people who can pay attention in court.
What's the state's position?
We are objecting to this. I think we need more information. The defense also noted on its filing that the first reason listed was because this individual is also the victim in a criminal case. So more follow-up would be needed with her. I know this court routinely takes stand-up breaks for the jurors because anyone can get tired in the afternoons. And so we'd ask to flesh this out more if she does make the box at jury selection.
This particular juror was flagged by the defense for a variety of reasons, but what concerns the court most is the identification of a condition that may interfere with this person's ability to concentrate in the afternoon, indicating that they sometimes fall asleep sitting up. If this were a 2-day trial, a 3-day trial, even a week-long trial, I wouldn't have this same concern, but this is a 5-week trial with, even with standing breaks and other things that out of an abundance of caution, I don't think this person is appropriate, and I'll grant the request as to 870. All right, 1261 then.
1261 is a person that also is, in this particular case, is a victim of ID theft. And we're asking that, in addition to being a victim of ID theft, the person's job requires them to be available, according to question 51. Although the person said they would do their civic duties, if called upon in 53, they asked to be a last resort. They think that this is not the right trial for 1261.
What's the state's position?
We would object. This is very close to just excluding a class of people because they've been victims of crime. Again, many people cited a hardship in regard to their employment as well.
I agree with the state. The request is denied. I will not exclude based upon a class of being a victim of a crime without more.
Hi, Lou.
Any issue or concern this juror had with the length of the trial is diminished by that juror's own answer. They clearly understand the importance of the civic.
Just prepping for Monday.
Questions at the appropriate time, but the request for 1261 is denied. All right, then turning next to 1393.
1393 is also a robbery victim, but in addition, there's more important information in that the person is a nanny and is responsible for care of another family's children. They depend upon her, and they provided detailed information about that. Furthermore, they will not get paid if off of work, and this person who is
Hope it goes well for you, house
income
hunting.
would be unable to pay her bills if required to serve for 5 weeks. I think that's an extreme hardship to somebody who can't pay their bills.
What's the state's position?
We don't have an objection.
All right, based upon there being no objection, then I won't stand in the way of an agreement, and 1393 is struck.
So this is just prep work for Monday, guys. So, I know we go through it, but I've never seen this before.
Thank you.
So
1405 has indicated, and of course we offer assistive hearing devices to people, but this person has chronic ringing in their left ear, in addition to the hearing loss, in addition to the migraines that happen that cause fatigue. And in a 5-week trial, I think that this is not the trial for this particular person who has the migraines that cause fatigue, doesn't know what would happen during the trial, hearing loss and chronic ringing in the left ear. This is a case where people have to pay very close attention to what's going on. It's going to be going on for 5 weeks, 4 weeks at least. And that's our basis for juror 1405.
We're objecting to this. We think those concerns could be something that this court would be able to accommodate. Additionally, this is another individual who is a victim of a crime. So we don't think that this additional information regarding the hearing loss is enough to escape the reality that this would just be a class type exclusion based on her status as a victim.
I believe it's premature to exclude 1405 at this time.
Jesus.
In part because
that's surprising.
the reference to migraines is that it is occasional. The hearing loss is something this court can certainly accommodate, and often does. Have many trials where there is a juror with the headphones or the assisted listening device. We just simply need more information, and of course, I will not exclude based upon a class of being a victim. So for all those reasons, I'll deny the request as to 1405. All right, turning next to 1988.
4 to 5 weeks.
Yeah, manages a small
It's
nonprofit.
gonna be a long trial.
No one that can do her work. Even when she's on vacation, she has to work. She has animals and has no one who can take care of them, of her animals. In addition, indicates that she cannot be objective because her neighbor got off after her neighbor shot her dog. In other words, the neighbor shot 1988's dog and got off, and indicates that she can't be objective. So for that combination of reasons, we feel this is a person that should be struck.
What's the state's position?
We're objecting to this individual as well. I think that more information would need to be obtained regarding what she meant by not being objective, since she related it directly to a very specific instance of, a criminal law violation in terms of killing a domestic pet, and that's not at all involved in this case. Additionally, I think she, like many others, would have a hardship not being at work, but I don't think we have enough information about that either at this point.
I believe it's premature to exclude 1988. While certainly there are some concerns with some of the answers, she needs to be given an opportunity to explain. There's also a very different
that's
type
fair.
of
So
crime
Monday
that
she
she
gets to
references,
explain.
not part of the allegations in this case, that being mistreatment of an animal. And so I will deny the request as to 1988 and she'll remain in at this point. Turning next to 2334.
There probably could be
334 is
a lot of alternates, I imagine.
a victim also of an assault, which of course this court has made clear that that's not going to be a basis to exclude her. Indicates that if the case has been on the news, she may already know about it. That's basically it, Your Honor.
State's position.
We're objecting to striking this juror for cause. I think more questions need to be asked in regard to both of the criteria outlined by defense.
Yeah, okay, that's fair.
It
That's
is
fair.
premature at this point to find that there's any type of bias or prejudice or
Why is it?
anything of concern related to this particular juror. Case law makes clear that even being at an event that is the subject of the lawsuit or case is not grounds in and of itself. It warrants further explanation. She does not provide any details and in fact makes reference to the wrong case as to what she has knowledge of. So we'll certainly have follow-up questions for her, but at this time the request to strike is denied. Number
Okay.
2398.
We were concerned about 2398 primarily because she doesn't really read, and then also is a stalking victim. There's going to be reading involved in this case.
All right, what's the state's position?
Thanks, Judge. The status as a victim of stalking is not appropriate to strike her for cause. The answer this juror gave regarding not reading was in response to a question about what her favorite types of books are. She did not indicate that she cannot read. So we're objecting to this.
I believe it's premature based upon the answers provided by this juror. We don't know if it's a complete inability to read or if any accommodation could be provided. And
This is a bit of a waste
being
of
a
time, I
victim
think.
of a crime is not an appropriate ground to be struck for cause. So I'll deny the request as to 2398. All right, turning next to 2607.
We'll withdraw the request to strike for cause that person.
All right, then 2607
Good.
will remain in. I presume there's no objection from the state to that?
No.
Okay. Then turning next to 2755.
2755 is a close friend with Judge Horlacher and is a victim of a sexual assault.
State's position.
We're objecting to this request as well. Same objection on the victim status. And then in terms of Judge Horlacher, obviously he's not presiding over this case and is not even in the criminal bench at this point. So I don't think that's an appropriate reason to strike him for cause.
None of the concerning aspects raised by the defense rise to the level of any type of bias, subjective
Yeah.
or objective. Being close friends with a judge on the Waukesha County bench in and of itself is not grounds to strike that person. And again, I won't strike anyone at this point for being a victim of a crime without anything more. So the request is a 2755 is denied.
So this judge is given the guidelines. She's not going to strike anybody that was a victim of crime or anything like that. So I bet most of the defense are going to object to. She could just list all these to the judge and say, these are them. You're not going to, I don't know.
All right, then looking at the next one, Juror 3000, I read
Yes.
through State versus Toddy, which is from 2008, 2009 Wisc.
Hi, Ann.
Different situation. That was the mother of the presiding judge was on the jury panel, and our
See you
Supreme Court
Monday.
said
See you
that
Monday,
this
Ann.
crossed a line and a conviction was
Mwah.
reversed. This is not, and I won't say the relationship because these jurors are confidential, and I think one could potentially figure that out. It's someone who, not at the moment, but in the near future, will be related by marriage to me. So what's the state's position on this one?
We don't have a position on that, Judge.
I think out of an abundance of caution, given the Toddy case, and in my discretion, if it's still the request of the defense, that I would grant this request. And I presume it is, right? Still your request that they be struck?
Yes.
All right, and again, out of an abundance of caution under State versus Toddy, I think this person would not be appropriate for this particular trial. All right, turning next to juror number 3207.
Well, that was a stipulated,
Oh,
was
there
it?
you go. I'll take that one out. How about 3329?
3329 is, we're asking for the person to be struck. Their home was robbed by a cleaning lady. Given the nature of the allegations here, it seems that they might not be able to be fair and impartial. They're also the primary income source for the family and scheduled to be out of town November 23rd through November 27th. The person is also a commission-based employee, so doesn't earn commissions when they're working.
As an aside, November 23 and 24, we are not in court on those days because that is the Thanksgiving holiday. The 27th is that Monday. We are still scheduled, although I am still hopeful we'll get done before the Thanksgiving holiday. But I wanted to make a record that the dates that he claims would be over the Thanksgiving holiday, and I think we would be able to accommodate that if, in fact, we're still going at that point in time. Meaning, I don't believe that presents an issue for the court. But what about the other issues raised by the defense?
The state would lodge the same objection regarding the class of victims of crimes. That should not be a basis to strike this individual. And then the hardship in the work and income source, I don't think we've agreed to some of those when they appear to be an extreme hardship, but we didn't think that this one rose to that level.
I think it's premature. We don't know enough about the business, whether it's, one or two person small business versus a large corporation where maybe the work could be absorbed, things of that nature. I've already commented upon the time being off. Court's going to be down in any event other than that Monday. I certainly want to know more information about when the trip was scheduled, whether the person could be back by the 27th, if in fact we're still in session, etc.
So
it's premature.
Thanksgiving. So we're starting on Monday, 23rd. That's 1, 2, 3, 4. 4 weeks would be the 17th of November. 5 weeks would be the 24th of November. So she thinks that they would be ending before Thanksgiving weekend. So she thinks this could be like a 4 to 4.5 week trial. Judge thinks it's probably 4 weeks then. For Thanksgiving weekend, it would be what, 23rd, 24th. I'm back. Okay. Okay. And then I need to look at what trials there are. I'll be December. If there's nothing in December, that's good.
This time, so I'll deny the request.
I might do Rittenhouse or something. Or Brooks. I don't know.
All right.
Or nothing. I don't know.
3515 indicates that after losing his mother and his dog within 2 months, and he says that he were the only 3 in the house on top of COVID, everything changed. He's very stressed. After dealing with grief for a while, he got another dog. His brother's disabled. His sister works. He doesn't know how he could leave him alone all day for 5 weeks. He is dealing with, in his words, extreme grief.
What's the state's position?
We don't have an objection.
All right. There being no objection, I won't stand in the way, and 3515 will be struck.
Karen.
All right.
What?
3651.
Karen?
The only basis was being a car theft victim, so we can withdraw that one.
Any objection?
No.
All right. 3651 remains. Juror number 3674.
3674 has indicated that there are personal reasons that he cannot serve on this jury, and would, out of respect to whatever those personal reasons are, we're asking the court to excuse him from this trial.
State's position.
I think that more questions need to be raised with this juror. The answers on the questionnaire were either non-existent or very, very vague.
I agree.
We lost.
It would be premature to find that there's any bias or prejudice on the part of this juror. More information is needed, so I'll deny the request as to 3674. All right, juror number 3766.
The court struck.
Oh, I did.
Oh, by the way,
I guess we're moving on.
Unicorn, her internet's still down. She can't get onto YouTube. Oh.
Hold on. So 3766 was already struck.
That's right.
All right, so I have next 4.
4302 was stipulated now.
Yep. All right, so that person's already. Okay, I'm on.
I'm hoping to Karen read before then.
What about 4337?
Yes, we're asking the 433.
It is a duplicate that was somewhere else? Okay. Hold on. Well, what would be the number then?
You would be in 4401 next.
No, what? Hold on. What would be the number for? That's the duplicate 4337.
They weren't stipulated list.
They were in the stipulated list. All right, I believe 4337. Let me double check. Yes.
Because
that
Karen
applicant's
reads in
already
March,
been-
isn't it?
So we are on 4401.
She can get on Netflix and stuff like that. She can't get on
4401 is
YouTube with
visually
a
impaired, doesn't
um,
drive. And by the way, there's a lot of
the
financial
road and
documents
stuff,
here that need to be able to
data.
be seen, that the state will be
But
introducing.
she's fine though. She's
into
fine.
evidence. There,
It
so
doesn't indicate she's blind though. She watches
No.
TV shows, so.
I didn't say she was blind. She said visually impaired, and they do not drive. Because, I mean, it's visually impaired dash do not drive. So person doesn't drive and is visually impaired. This is a complicated case. It requires vision, good vision.
Attorney Nicolai on 4401.
Judge, we're objecting. This appears to be a class type exclusion based on disability.
We don't have enough information. I agree it might certainly be important to be able to, review the evidence, whether that's reading it, seeing it, hearing it. We don't have enough information.
I will be covering it.
And that includes her ability to get to the courthouse each day. So we'll take a wait and see approach. I'll deny 4401.
So
Four,
we'll
four, two, four
do
was already
Karen
agreed to?
Reid
Yes.
as
So we're on
videos
4,
rather
4,
than
2,
the
2.
live
Based upon
stream.
the court's position that being a victim of a crime is insufficient, we'll withdraw.
All right, we'll certainly can ask more questions.
I
at
think
the
so,
time of the
yes,
hearing second
yeah,
conference. If they'll leave in,
yes.
Thank you.
She was old as well, I
Okay, we
believe.
should be at 4450 was already a stipulation,
Right.
Yes.
and 4452 would be the next individual.
4542, I show. Is that right?
If I flip the numbers, you are correct. 4542.
We are asking the 4542 be struck.
By all
due to
counts, it's
his,
just
Each other.
they're just
The only
going
reason I
through
raised this
this.
is because I tried a case with a court officer and the courtroom was not configured. And actually hired her to do the jurors' estate planning. Attorney Taylor will testify at this trial.
how do we know that juror 613 knows Beth Taylor?
It's in the questionnaire.
I'm sorry that I don't have that one with me.
I'm sorry. And
Let me
we,
take a pause. I'll have I have the ones that were not contested initially in the back. Ryan, if you want to go grab that for me, I can look at it. And then if you don't have yours here, we'll just let you look at mine at this point.
Thank you.
I'll just skip it a bit because, like, she's not gonna decline
Each other.
anybody.
the only reason I raised this is because I tried a case with a court officer and the courtroom was not configured to fit us all at a table. And there was nothing that could be done about that. We ended up having to, it was not conducive to the amount of parties that were involved in the trial. So I just want to make sure that the accommodations that were made for both defense and the state in that matter that this court heard are going to be the same for this case.
I'll look into that.
Specifically, the front table for the state was longer than this table that's in here because all three state's attorneys sat at it. The table behind the state had a connection to the
So
system.
let me just stop you. The tables that you see in the two links are the tables that we have. They are smart tables that, in order to fully function, have to be in a certain spot. My recollection, though, is the larger tables from another courtroom were put into the front spots, but there's no connectivity then when that is done. And then because the way that these were configured, and it's just the technology that we have, the larger tables, like this is why I had you all at the tables that you're at so you all could fit, but had the connectivity.
That's fine.
So what I'm saying is I'll gladly try to work that out so that you have the larger tables in front, but if you need connectivity, I can't do that in the front tables. You only have connectivity, meaning to be able to display your evidence from a computer, from the back table. Now, in that other trial, the paralegal took care of all of that. I've already made orders related to who can be at what table or who can be in the gallery, not the gallery, who can be in the well. And so I'm not going to revisit that. That's already been approved. But just so you understand the limitation by putting large tables in front.
Understood. And we will have the same procedure as that trial where as long as the rear table has connectivity, that would be fine. And I think we'd prefer having a larger table for the three of us in the front without connectivity.
It will be the same size that you have
Okay.
right now. And I don't have any other tables, and I don't believe we used any other tables, but I'll look into that.
Okay.
Will the defense have any issue if you have a longer table but without connectivity in the front? Do you know what I mean by that?
I do know what you
Okay.
mean by that, but I'm not sure where I'm not in that courtroom, so it's hard for me to envision where we're going to sit. We want connectivity. So we would sit at a table that has connectivity.
All the tables, as they're currently set up, have connectivity.
All right, well,
The,
this
the
setup-
issue is the size of the tables. You will see the table in front of you right now is shorter than the table at which you are currently seated. So if you choose to all sit at the back table because it's a little bit more comfortable for three people, I can either remove that other table so there's nothing in front of you, But if you wanted 3 people more comfortably at the front table, it would not have the connectivity to the audiovisual system.
We wouldn't want that, so we'll just keep the 2 tables.
And we can look.
What?
We'll do all of this offline.
Okay.
We'll make sure we touch base with Zach Tremaine. But I'm about 99.9% positive about what I'm saying.
Okay.
And then look at the schematics we had for that other trial.
Okay.
But that's my recollection is the front tables were larger but did not have connectivity.
Okay.
It was only the back tables. It's a mirror image of this, but larger, so that because the jury box is on my right in that courtroom. And so the state would be on the right if you're me,
Right.
left if you're looking at me, and
Mhm.
the defense will be on the other side. So
I also had jotted down having a table for exhibits set up. I think in that trial, there was one kind of toward the front of the courtroom. There are going to be many, many, many exhibits in this case.
So I think the difference on Monday, if we get to see you, Sylvia, is going to be they will have to strike people. Where now they're literally just pushing it into Monday. Let's have a look Monday. Where Monday they can have to decide, make decisions. So that'll be exciting, I think. Also, hang on, for people to know, because you'd like to know, you're nosy, all of you bloody nosy. For dinner, white rice, sweet and sour chicken, bit too much rice. But because you're nosy, I know. There you go. You've seen it all now. Yeah. There you go.
And I'd like to keep them organized between trial days so that, because we're going to reuse them with various witnesses, so that we can keep them in order. and
Oh, I
grab
know you
them
want
if
to
we
see
need
it. I know you want to see
I'll
it.
take that under
Sylvia.
advisement. I need to make sure we have that availability as well.
Okay.
That's what I think Mondays could be.
I was going to
Mondays
ask
could
this
be better.
court respectfully for a refresher on how you want the exhibit process to work, because I think there's a little confusion on our side in terms of what the court wanted ahead of time, and then I know perhaps your practice has changed since that last major case in terms of having exhibits e-filed. So I'm just asking for a repeat of that information, please.
Let's do that discussion offline with the attorneys in the court and my clerk.
I also note I was contacted by an attorney with Corporation Counsel yesterday.
There's nothing better than 3 ways. That's it. Spaghetti, chili, and cheese. Ooh.
Inquiring about some subpoenas that were served on correctional officers. And when I actually looked back into that and refreshed my memory with the last jury status we had, similarly to what we discussed at the beginning of this hearing, the court had made an order that if there were going to be other acts about Magdalena Sabaniak, who was a jail inmate with the defendant, that another acts motion needed to be filed by February 3rd of 2023. And so my question is, given that was never filed, what the offer of proof is for these 2 correction officers, because I believe Corporation Counsel would be interested in avoiding having them produced if there's not any admissible reason for their testimony.
I'm not going to address that here today. I don't have a motion in front of me. I mean, Corp Counsel knows how to file a motion to quash should they deem it appropriate. At a minimum, the party should meet and confer over that. And then if there's an issue, file an appropriate motion.
Okay, thank you.
Is there anything else then from the state?
Would the court be able to provide the parties with a list of the first 50 jurors coming in on the 23rd, maybe the Friday before, just so that we can?
Yeah, that's a great question. That is my intent, is to, once we get through with this, to talk with the jury coordinator and tell you who the first 50 will be. My answer over that. If there's an issue, file an appropriate motion. The state.
Would the court be able to provide the parties with a list of the first 50 jurors coming in on the 23rd, maybe the Friday before, just so that we can?
Yeah, that's a great question. That is my intent, is to, once we get through with this, to talk with the jury coordinator and tell you who the first 50 will be. When they come in, though, they will be randomized. But we'll know the 50 that they come in, if that makes sense. I'm doing 50 per day. That was in consultation with facilities, given the court construction process and parks and planning, because they're in charge of all the parking and all of that. So given some of the limitations, I agreed that only 50 would come in per day. I've worked with them to make sure all jurors have adequate parking, and along with the sheriff's department, they've been phenomenal to make sure the accommodations are here for all of our jurors. And so it will be 50 per day until we have the magic number of 30. Once we know we have 30, maybe it's the first day, maybe not, then the parties will do their strikes, their preemptory strikes.
Thank you. That's all I have.
All right, how about from the defense? Anything?
Yes, Your Honor, a couple things. First is
So that's interesting. 50 per day. So potentially we could go on for like 3-4 days. So they won't get down to 30. Oh my day. So literally they could fly through 50 in in a couple of hours.
document 213 that we filed requesting that Dr. Sameh, S-A-M-E-H, be allowed to testify by Zoom due to her autoimmune condition. That I think her risk management attorney has reached out to us and asked for special consideration for her.
My understanding is she's in the medical field and has an active patient practice where she sees people. Is that right?
Maybe Attorney Galavis could better answer this. He's the person
I don't want to make assumptions, but
subpoenaed her. He knows the facts of that better than I do.
Judge, that I don't know at this today whether or not she still sees patients because of her medical condition, but back in the day she was one of Ms. Hernan's providers and did see her on occasion. Today, whether or not she's doing that, I'm not sure. I could find out. She is represented by legal counsel.
what, and I don't have any motions related to this, but how long do you anticipate her testimony would last?
An hour?
What's the state's position?
I'm sorry, I didn't hear counsel's answer.
1 hour, he said. So this apparently is a treating physician of the deceased. And I don't need an answer yet here today. I would have preferred a motion. I mean, my specific response to that request was I didn't have enough information to either grant or deny it, and I didn't know the state's position. Just like I didn't address some of their requests because I didn't have a motion in front of me. I think it's important that the parties meet and confer on this, and if need be, an appropriate motion be filed, since our purpose of being here today was really for the jury questionnaires.
Correct. If I remember right, the state didn't have any objection to the Zoom request.
Well, I don't know. They didn't.
That was not relayed. We were provided this letter and I indicated that we would look at it, but I did not. My concern is showing this person physical exhibits because there are many medical records that I won't be able to hand someone on Zoom. That's my concern.
Well, meet and confer. Perhaps there can be an agreement on whether this person testifies by Zoom or not. We clearly have the capability. Okay. I have the ability through the Zoom application to share, just as you exhibits for this person. It's a little bit trickier during a jury trial. You have to think about the person's on the screen. It's a very large screen. Okay. And they're on both screens in my courtroom, along with the monitors in the jury box. And so if there's an agreement, or if I allow this, do I need to give some type of limiting instruction or cautionary instruction to the jurors about not putting more or less weight because they're remotely or because of how they're depicted? Every witness in the courtroom sits, it's to my left here, but downstairs it's to my right. And they're in person and they're life size, not, I don't know, 10, 20, 50 times bigger on the large monitors. So there's some real practical considerations. We obviously did a lot of the Daubert hearings but we had all those witnesses and it was just for the court. I'm not opposed to it, but I want the parties to look into it. I prefer if we do it, there's an agreement and you address things like how will exhibits? Is there an agreement on what the exhibit is? Can it be provided to her ahead of time? Or simple questioning on the day of the testimony, we can confirm. Where will she be testifying from? I do not want it from her home, right? If it's an office and can it be, and no one else is in there with her. If she has an attorney, that's different, but I need to be provided with that information. So there are way more questions that I have. So I'm not in a position to be able to answer that here today. Whatever the request is, though, if there is a renewed request that she appear by video to testify, that must be filed no later than Wednesday morning at 9 a.m., along with any other motion on this witness that I declined to admit here today. That was the addendum. I indicated I need a motion. Same thing for the state. If court counsel is going to be filing any type of motions to quash, everything needs to be filed by Wednesday morning at 9 a.m. so that I can appropriately schedule a hearing, whether that be the morning of, whether that be we get the jury picked first and then I address this, like Wednesday morning or something of the following week. I will look at my calendar. I'm very full, trying to get a lot in before this trial starts, but that's how I'm going to address all of these things. Were there any other issues from the defense at this point?
Yes, one other issue, Your Honor, is that we're asking this court to order that we have a presentation of a trial schedule that puts forth the witnesses and the dates and the times that the witness is anticipated to be called to the stand. Of course, things are fluid in trials, so there can be changes to that. It's very difficult for the defense with a trial of this length to not have any indication at all from the state as to who they're going to call when. I recently just concluded a 3-week trial before Judge Waterman up in St. Croix County. I brought with me the letter he issued to that effect, indicating that he expected the attorneys to confer and give a proposed trial schedule so he would know who was going to be called when, have a good idea how long they were going to testify so that we could run the trial in an efficient fashion and so that people could be properly prepared. knowing that there's, dozens of witnesses. And and he indicated, of course, that the attorney should be realistic about the length of time that they anticipate for direct and cross. So he knew how his courtroom was going to be run, how he was going to run his courtroom, and what the days were going to look like, not just for him, but for the attorneys. And I asked that this court consider that in this case, because obviously there's a lot of witnesses.
I'll take it under advisement. I'm getting this request of, a week, not even a week and a half before the trial. And I'm mindful that both parties are preparing. I would have certainly entertained that had it been a request when I did the trial order. I don't know what type of time commitment, resources it would take the state and the defense to do that. So I would just ask that you meet and confer on that. Maybe there's some agreements you can all reach. Maybe it's just a list of when you're, the order. I don't know. But for a trial of this magnitude, I think to ask this court to do that at this time, I think it's kind of unfair to the parties.
Judge, we did talk about this, and that's not something the state is agreeing to prepare for the defense, so it would require a court decision at this point.
Right. We did bring it up with the state, Your Honor, and asked if they would work with us on the order of witnesses, and they refused.
Well, again, this should have been raised months and months and months ago. This is the second time a case has been scheduled for trial, so I'm not going to issue that order. It's a great idea, and under other circumstances with ample time, I most certainly would have granted it. But I think to do that, it is, October 13th, the trial starts on October 23rd, would be to take away from the prep time that has already been set aside by both sides as relates to this.
Would the court indicate that at least on a daily basis, we could be provided with the witnesses that would testify the next day?
Not at this time. So again, that request should have been made months ago. I'll wait.
Wow. That's bizarre. I thought it was standard practice that you'd give a list of, like, maybe not ahead of time every day, but not even the day before. So literally, the state could call whoever they want, and the defense don't have a clue. So they're going to have to prepare for every single witness well ahead of time because they won't know who they're bringing. Oh, that's harsh. I don't like that, but Judge, I think you should be able to say who you've got the next day. Jesus, that's harsh.
And see how, bottom line is I set aside what is a portion of 6 weeks, 25 calendar days, so that there's ample time. I'm not going to interfere at this point or order the parties and micromanage the way that they call or the order that they call their witnesses, not at this late stage. Now, I would like to raise one other thing. I did have my clerk send to the parties the revised script for jury selection. It takes into account prior hearings. It takes into account that the process for jury selection is a little different. It's not different. It's just that the prior script anticipated remote viewing by jurors. Obviously, we're not doing that. So I took out some questions that were related to that. I have some instructions for purposes of the parties saying that we'll bring in 50 at a time, that I will be questioning all jurors. The seating arrangements downstairs, because we do have a little bit more room in the well, will be that, and it's in the trial administration order, but we have those in the jury box. We have 2 rows, I believe, in front, and then I'll be utilizing 2 rows, right? I think it's 2 full rows from right to left or left to right, however you're looking at it, with jurors, and then there's limitations on who sits where, etc. So just be mindful of that, but it will require the parties to be able to, swivel in their chairs to look at jurors who are providing answers. I contemplated, just doing those, what we would call in the box, whether they're in the actual box or the rows in front of it. But I really want to get through 50 jurors. And I think it'll be much easier given the length of the script if all 50 are questioned. So we'll start with those in the box. I'll go through their biographical. We'll continue. They'll all have numbers on. I'll identify them by numbers. We'll go through all of that. And then those specific questions will be asked. And we'll go from there. That hopefully takes us, no more than a day for each 50, but I'll be prepared to adjust if need be.
Will the court be referring by pool number?
So what'll happen is when they're randomized, they'll get a jury sticker, which starts with 1.
Oh,
and
so
go through 50.
different.
And that's how I will be referring to them during the jury selection process. Depending on, that can only happen the day of, and I believe Lauren will be able to put a spreadsheet, at least of numbers together. And so if I'll do my best, maybe I'll cross-reference with a second number, like the, what's the top one? The juror ID number, the pool number. So they'll have their pool number and their randomized numbers. I'll do my best, at least initially, to start with both. Because these jurors will still have their questionnaires. They're going to get a supplemental questionnaire, as I told you previously. I don't know if I've sent that to the party. I was working on finalizing that. It's pretty simple. One is, please review your questionnaire. Is there any answer that would be different sitting here today or that you'd like to supplement? The second one was based upon the request of the defense to recognize any other juror. I was having a discussion about what number they would see, if any, And I'm going to require that they get their randomized number before they're given the supplemental jury questionnaire so they can say, oh, I recognize juror 43. Some of these people, they truly recognize each other, might even be able to do that without numbers, but I thought that was important. It's a question in the script as well, but at least you'll get that ahead of time. They'll fill those out. We'll make sure all the parties get copies of those supplemental before the jury's actually brought in. I know for myself, I will have a folder for each one of the jurors, and that will be put in, and I will be able to, look at all of that. It'll be up to you how you all have those, whether it's electronically, given the flash drive that was previously provided, or if you print off copies on your own and have, like a 3-ring binder or folders or whatever it may be. But I would highly encourage you, however you're printing them out or however you're doing it, that you have at least those 2 numbers in your spreadsheet, for example, or somehow readily identifiable on the first page so that we're not kind of fumbling through all of that. And I'll make sure once I confirm with Lauren, our jury coordinator, that you all get a copy. It's 2 pages, or it's 2 questions for the supplemental, and then it has a number of pages with just lines so they can handwrite, and it's hopefully helps with legibility. But that's really all I have. I do intend to start each day at 8:30. My experience is typically the jail on trial days will have Ms. Kurczewski available. I'm hoping it's not like it was today and late, but that she's here and available no later than 8:15 each day.
Judge, on your questionnaire or your script, could I just ask one thing on that script?
Sure, let me pull it up. Go ahead.
Thanks. When you get to page 4 on that script and you discuss whether the potential jurors know any other attorneys on the district attorney staff, would you also please mention when you come to Attorney Galaviz and myself that I'm with Kukler and Cotton, and see if anybody knows any attorneys in my staff?
Usually I have a question that says, would you please identify where you work? I can add that.
And I'm looking at page 4 where
Yep.
you number 10, do you know any other attorneys on that staff, speaking of the district attorney, but nothing about our firm? Just to be sure.
Attorney Galvez, what's the name of your firm?
Galvez Legal.
Is it just you and your son, or is there anyone else?
Just me and my son, Adam.
Him and his son, or his brother.
Based upon his letter, quashed the subpoenas because I couldn't comply with his request because I had no idea when I was going to call these witnesses, because I have no idea when the state's going to finish their case. So
That was
he's-
based upon the fact that it listed an entire 5-week timeframe.
correct. And I was working with him via telephone trying to confirm like the week and possible day that I was going to need the witness, and he basically told me that wasn't good enough.
Let me be clear. I expect the parties to meet and confer, and as officers of the court, understanding you are taking not just this court's time, your time, but members of the public as jurors and the victim and Ms. Kurczewski's time, that you work this out between the two of you, or between these 2 teams, and come up with a scenario that works. Then, absent any additional filings, we'll see everyone on Monday, October 23rd at 8:30 a.m. Yes, Attorney Galaviz?
Judge, going back to that request by Ms. Kukler to try to get the state to give us a time frame as to when they're going to be calling their witnesses or when they're going to be able to conclude their case. Back when this trial was set in February, March of early this year, the civil attorney representing Dr. Smith and Dr. Albulal filed a letter with the court. He was basically upset that I couldn't give him a time frame as far as date and time that I'm going to need the doctors to testify. So he filed a letter with the court. And you, based upon his letter, quashed the subpoenas because I couldn't comply with his request because I had no idea when I was going to call these witnesses, because I have no idea when the state's going to finish their case. So
That was
he's-
based upon the fact that it listed an entire 5-week timeframe.
correct. And I was working with him via telephone trying to confirm like the week and possible day that I was going to need the witness, and he basically told me that wasn't good enough.
Let me be clear. I expect the parties to meet and confer, and as officers of the court, understanding you are taking not just this court's time, your time, but members of the public as jurors and the victim and Ms. Kurczewski's time, that you work this out between the 2 of you, or between these 2 teams, and come up with a scenario that works. That's reasonable, and I think that's what attorneys are expected to do. I'm not entering an order, but I do expect the parties to have some reasonable timeframes, whether it be we expect 5 witnesses today, or whatever it may be. But you got to try to work through this first before I step in.
Correct.
Judge, we did that. I want the record to show that we did do that. And we had a discussion, and I told Attorney Kukler over the phone, we anticipate having 8 to 9 days of testimony. Depending on how long jury selection takes, that will give a very clear window for the defense when they should be ready to begin calling witnesses. That's been done.
What I would expect to happen, since I'm getting a lot of clear, we're not going to give you much more than that, is after each day, you just give everyone, both sides, give the ballpark of who you expect to call the next day. I think that's reasonable, right? And I appreciate the 8 to 9 days of testimony. I think I recall that now. That might have been said. I think that's probably why I was hopeful we could get this done before Thanksgiving. But that's all I'm going to do at this point. Okay.
There's one more topic that my client wanted to bring up to you, so I'm just speaking on her behalf, and that deals with court docket 229.
If that's her letter,
Correct. That
she needs to meet and confer with all of you. And if you think an appropriate motion needs to be filed, I'm not addressing it. That's what she has an attorney. I appreciate she filed it. I appreciate she did what I said I would expect to happen before any issue would be raised, but requests need to be made appropriately. And she has counsel and she needs to work with her attorneys. So if any motion needs to be filed as it relates to that, it needs to be filed by Wednesday morning at 9 a.m.
Yes, Judge. Thank you.
All right. Thank you, everyone. That concludes the hearing. Then we are in recess.
Kind of a joke.
Oh, actually, one other thing. Sorry, there's a reason this TV's up here. We have the ability in the courtroom to have, thank you, Madam Clerk, 2 TVs. And if you can see, can you put on the questions, Madam Clerk? I want to make sure that the jurors who are in the gallery are able to see those. So that will most likely only be there for jury selection, but we have these smart outlets on both sides. I just only brought in 1 TV for purposes of today. But during jury selection, to make sure the jurors can see that, it will also be on those monitors on each side because jurors will be in rows across. Thank you, Madam Clerk. I forgot about that. All right, now we're done.
Thank you.
Have a good day, everyone.
You too.
Have a good day. Here she is. What this? Oh, look and grab it. Jesus. I don't like that a man's doing that. Like, get a female to do it, man. Jesus. Don't like the way he grabs her from the. Anyway. Right. Because we got hens for y'all, if she's still here, let me play this for you. This is from Skyline Chili. This is this week, and I laughed my head off on it. This is Feitelberg fights. So he's having Skyline Chili for the first time. Watch him eat. Watch him eat, right?
We're in Cincinnati. We got a show tonight. To be honest, I don't know what it is. But I don't even know what time it is. What time is it?
I have no idea. No fucking clue. 8 o'clock? I don't know.
We got a show sometime tonight somewhere in Cincinnati. Obviously, the first thing you gotta do, you gotta try Skyline Chili. And I gotta tell you, I'm digging this. It's really good. If you want cheese and beans and onions and spaghetti and cinnamon, like there's only one place you can go get.
You see, fights.
Dude.
Right,
Fantastic stuff.
This.
We're in Cincinnati. We got a show tonight.
The Bibs, yeah. Hang on, let's go. Lou, what's Lou saying? If she did it and wore gloves, so no fingerprints, it could be difficult to prove. Sounds like it could be very interesting. I think she wore gloves, so no finger. I think she's admitted that she gave. She's given the drink. I think she's admitted that she gave the drink to the victim with the poison in it. Unless I've read that wrong. Happy Daisy here. So I'll play it again, right? The bibs. The bibs are fantastic. Watch him. He doesn't even chew. He just swallows it. I've never seen anybody eat like this before. Doesn't even chew it. Just straight down his throat. I've never seen anyone eat like this before.
To be honest, I don't know what it is. But I don't even know what time it is. What time is it?
I have no idea. No fucking clue. 8 o'clock? I don't know.
We got a show sometime tonight somewhere in Cincinnati. Obviously, the first thing you gotta do, you gotta try Skyline Chili.
Down, swallow.
And I gotta tell you, I'm digging this. It's really good. If you want cheese and beans and onions and spaghetti and cinnamon, like there's only one place you can go get.
I watch him. It's like, how's he eat?
Dude. Fantastic stuff. We're in Cincinnati. We got a show tonight.
KFC Radio, Barstool. I listen to Skyline. I've heard of it because obviously the Bengals, but I don't. The only reason I've heard of it because the Bengals and people who support them always say it. Oh my God, he did just what he does. That's how he eats. It's normal. He said that's how he eats. And so that's how I knew the spaghetti was in there. The first time ever he had the spaghetti, I saw the picture. Cinnamon in chili and spaghetti. Ooh, never heard of that before. Nunia. You see, Nunia's from Kentucky, so Kentucky Fried Chicken, a Pizza Hut, McDonald's, Kentucky Fried Chicken and a Pizza Hut. Damn, yeah, I eat fast, but at least I chew some. It must be just this, but it didn't even chew. How does he poop? I had no idea. That's incredible, though, isn't it? I thought I'd share that because I thought it was funny. So anyway, we are here. So we're going to finish now. Some say it's not actually chili. Some say you're KFC for lunch. Some say it's not actually chili, but chili sauce. Oh, didn't he just say cinnamon? Oh, maybe he did. I don't know. Oh, I don't know. I'm not. I was more intrigued to see him eat. That bloody songs. Yeah, I know. Sorry. Every time I see that, uh, Kentucky Fried Chicken and a Pizza Hut, McDonald's. I'm sorry. I'm sorry. Um, so it's been good. Sorry, it's been a long stream, longer than I anticipated. Right, Sarah P. Yes, he did, Junior. Hopefully, Sarah P. You're in a good mood with me because you weren't earlier on. But mine is all love, Sarah P. All love. Ooh, all love. Um, yes, there's cinnamon in it. Ah, okay, okay. Actually, leftover spaghetti sauce make great chili. Okay, sounds gross in my opinion. Sorry. Yeah. Might not be for everyone, but I have to try it. I'd love to try it. I have to go out to Cincinnati to try it. I don't want to try one of the tins. So also how I know a lot of Cincinnati is Dick Beers supports the Bearcats, Cincinnati Bearcats. So noodles are the best. I love noodles as well, dude. It wasn't long. What happened to tennis? I'm gonna watch that. I'm sorry. Sorry. No, you see, she's ignoring me now. Me too, Nania. I'm not for cinnamon and chili. I don't know. I think he'd be all right. I think he'd be all right. Um, what you can do is go and watch Frankie, the Delphi stuff, or I've got loads of playlists in my on my channel. Just look at one of the playlists. You know, so there's lots of playlists there for different trials. Kohlberger, Travis Rudolph, the OnlyFans one. Take your fancy. There's lots of playlists there. I'm sure people haven't seen. So take a look at my playlist, guys, if you want to have a look at some other trials as well, or some other topics, shall we say. So yeah, that's all I got. I got my nieces coming over tomorrow doing homemade pizza and chocolate cake. Homemade chocolate cake. So you know, so that's what I'm gonna be doing really. And I like cinnamon rolls. And I'm gonna be hoping next week the Sarah P is in a good mood with me. But actually pretty subtle. You'd like it. Okay. Not a fan of cinnamon set for a few desserts. Yeah, cinnamon rolls and stuff I like. Marmalade sandwiches. Lou. Marmalade on toast, yes. Marmalade sandwiches. No, thank you. I know it's not much of a difference. Actually, do you know what? I had marmalade toast today for lunch. That's why I had marmalade on toast. But I can't imagine eating in a sandwich. Cinnamon belongs in the dessert, yes. Put a little cinnamon in my meatloaf before, but not always. Let's talk about sweet stuff now. So Monday, if they don't show the trial on Monday, hopefully show jury instructions as they've done today, as in last week. If not, they'll still stream for a little bit, and we'll just watch some cars, car chases and some crap like that. We'll just talk crap until the trial actually happens, because we don't know when the trial's actually going to properly happen. But I'll be here for it. Do you know what I mean? So we can switch straight to it whenever it does happen then. And they normally give a bit of a warning. So so there we are. That's what the plan is for Monday, 8:30 Central Time. I don't suspect they're going to start at 8:30. Do you know what I mean? So I don't think there's any rush to be here at 8:30 Central, 9:30 Eastern, 2:30 UK time, 3:30 European time, or yeah, 6:30 Pacific time, or 7:30 Mountain time. So I think there's a massive rush for that on Monday. Hopefully by Tuesday we start, but we'll just have to see with the jurors. It might even be Wednesday, Thursday by the time we start. So I think the two are they're biting at each other. You could tell they don't like each other already. So I think there's going to be a lot of fighting between attorneys as well on this case. So be good to see how the judge deals with it. I think she's dealt with it quite good so far. She seems don't mess about, don't fuck about, guys. Otherwise, if I have to get involved, then he won't like it type of attitude, which I like that. I like that. So yeah, so that's what we got there. So thank you to everybody for being here today. Shout out to the think tank for becoming a TACO member. Appreciate you. And thank you to Rosie for being a Blue Wench member. Thanking you, Rosie. So I appreciate you guys for becoming members. It does help me out loads. So hence for you all, thank you for subscribing and for being here as well and chatting as well. Really appreciate you for that. And we've got Sarah P. Oh, thanks for streaming, Dan. Oh, my pleasure. Thank you for being here today, everyone. See you all next week. Have a great weekend. You have a great weekend as well, Sarah P. Sarah P, put your feet up, enjoy yourself. Lay your husband, make you smile, and be good. Miss you all over the weekend, but may see you on other streams. You will not see me anywhere near any of the streams, but I'll be working on some stuff in the background. And I might do some videos and post some videos, but not doing streaming all the weekend. Hence, we all have a good weekend to you as well. Hopefully, see you Monday. Take care of yourself. Take care of yourself as well. Thank you for being here. And with that, guys, we're going to end the stream. Free Zachary Anderson, as always. And take care of yourself. Have a great weekend. See, hopefully, all of you on Monday, 8:30 a.m. Central, 9:30 Eastern, 2:30 UK time, and 3:30 European time. And if it's not, and it only just they don't show the jury selection, then we'll do something else. So don't worry. Wasn't talking. Thank you, Nania. Wasn't talking to you then. Oh, okay. Sorry, Emma. That's fine. Thank you, Dylan. Sorry, only joined at the end. See you on Monday. Happy days. No worries, Lou. Welcome as always. Good night, Thierry. See you, Lou. See you, Thierry. End stream. Free Zachary Anderson. See you later, guys. Ta-ra.